on the defense's motion of an illegal arrest without probable cause. And are the parties ready to go forward?
Yes, Your Honor.
Mr. Kalachek?
I'm ready to go forward on that motion.
Okay, the court's goal today is at least to get all the evidence in place at the hearing today. I have received the 4-inch binder from the state with the defendant's motion to suppress statements and all the transcripts that I'll have to go through. But we want to get the testimony completed this morning if all possible, okay? So go ahead, Mr. Kalachek, call the first officer.
My first witness is Sergeant Wexon.
Okay, come on up, sir. Huh? Okay, and who do I have on the overhead so we're clear today?
Chris Provost, Your Honor.
Okay,
And Austin Barrett.
okay.
Do you swear or affirm that the testimony you will provide will be the truth, the whole truth, and nothing but the truth?
I do.
Have a seat. Can you please state and spell your first and last name for the record?
Yep, Tony Wegzin, T-O-N-Y-W-E-G-R-Z-Y-N.
Your occupation?
Alaska State Trooper.
Thank you.
Go ahead, Mr. Kalachek.
Good morning.
Good morning.
Sergeant Wexon, I'm going to go through some ground that we've covered numerous times before in other court proceedings. First of all, tell me, in the year 2016 specifically.
Your Honor, we can't hear on the phone.
Oh, you got to move the mic. Sorry about that, guys. A podium mic got broken in this courtroom, so we'll have to set up one at a time when you do your Go ahead, Mr. Kalachek.
Okay, thank you. Let's do a test. Is that better?
Everybody online hear that?
Yeah, that's great. Thank you very much.
All right.
Thank you. I'm gonna, as I was saying, I'm gonna cover some things we covered numerous times in other court proceedings with you. So turning your attention to November of 2016, can you describe your employment during that time and your duties?
Sure. I was the supervisor assigned to the Major Crimes Investigative Unit. We handle all sexual assaults and serious felony assaults as well as homicides.
And turning your attention to mid-November, did you become involved in the David Grunwald case?
I did.
And describe how you became involved in that case.
I heard that that David was missing on November 13th. The morning of November 14th is when I actually heard it. I know that we had discovered his Ford Bronco burned up off of Sites Road. I had actually taken the position in the Major Crimes Unit at that point, but I was in transition between my previous assignment and that. And so I gave some direction to the investigators in the Major Crimes Unit, and then on November 15 and 16 is when I became heavily involved in the investigation.
Okay. And then fast forwarding, eventually a number of individuals were charged with crimes relating to this incident.
Yes, sir.
And you have been the officer in charge on the cases throughout, correct?
Yes.
All right. The subject of the hearing today is Austin Barrett's interview, detention and interview, starting at the Palmer Post and ending at the DA's office on December 7, 2016. Are you familiar with that event?
Yes.
I want to, before we get to that event, I want to backtrack because my intent during my presentation is going to be to establish for the court what knowledge you had and of the case, and more specifically as to Austin Barrett's involvement in the incident before he was interviewed on December 7th.
Okay.
So, which necessitates me to go back to the first contact you had with any of the suspects during the course of the investigation. And I believe that takes us to defendant and now convicted murderer, Erick Almandinger.
That is correct.
So can you tell us what led you to focus on Almandinger first?
Sure. So we received information early on, real early on, in fact, the day of, if not the next day, 11/14, 11/15, that there was a probability that David had gone to Erick Almandinger's residence after dropping off his girlfriend Victoria, being that we couldn't find David. He was still missing by November 16th. I stopped by Erick Almandinger's residence in an effort to talk to him about what he knew about David's location, where he might have been, where he might have gone to, because that was the only lead we had at that point, at least as far as I remember.
Now, when you had your initial contacts with Erick Almandinger, did he admit being involved in the murder of David Grunwald?
No, he denied being involved with anything related to David Grunwald.
And did he present an alibi to you?
He did.
What type of alibi did he throw at you?
That he took a cab from his place in Palmer into Anchorage to an unknown location and was at a party all night in Anchorage.
And during your investigation, were you able to undermine that alibi fairly quickly?
Yes.
And tell us, what did you discover that proved that Erick Almandinger was lying to you about being in Anchorage on that evening?
His primary mode of transportation that he claimed that night was through Premier Taxi, and it was a quick call to Premier Taxi to discover that Premier Taxi hadn't picked anybody up in Palmer and driven him to Anchorage that night. So that was kind of the leading indicator that there was something off with his story. Additionally, he alibied himself with another male that we were able to track down, and that man, Anthony Herring was his name, ultimately said, no, I wasn't with Erick that night either. So there was a couple of very big errors with his alibi that we latched onto pretty quick.
And so he was one of the primary suspects early on in the investigation, correct?
Yes, sir.
Right. And can you tell us what information led you to the other suspects?
Well, ultimately, Erick did end up through, I think, the third interview, letting us know that he had gone to, I believe it was Alyssa Bledsoe's place, and he had mentioned Bradley. He had mentioned somebody by the name Bradley, but didn't use Bradley's last name. And through that, we were able to ascertain that he was probably talking about Bradley Renfro. And we ended up on a traffic stop with Bradley Renfro and Alyssa Bledsoe later on in the following weeks.
And in addition to contacts with the suspects, was there some other information such as videotapes or information from cab companies or phone companies that pointed to some of the other suspects?
Sure. So a canvas of sorts was done on all of the gas station. Well, actually, any place that had any video, but ultimately we ended up with gas station video from the Selden and Church Food Mart, and that showed a cab going up Church Road towards Schrock, and then coming back a few minutes later. The timeline was about right to be picking somebody up in the area of the burned up Bronco the night that it was burned up. And through that, we were able to discover the person who called that cab was Dominic Johnson. And then we interviewed the cab driver, and we interviewed Dominic, or tried to at least.
All right. So was the phone number that Dominic Johnson had, that phone was used to call the cab?
Correct.
Okay. And then in terms of the video, your investigators obtained video from the Holiday gas station?
We did obtain video from the Holiday, excuse me, later on in the investigation, the one at mile 49.
Right. And the video was obtained before the interview with Austin Barrett on 12/7 that we're talking about today, correct?
Off the top of my head, I can't remember, and I'm sorry, I'm drawing a blank on the date we pulled the video from Holiday.
All right, maybe I'll have you look at your report, we'll
Okay.
get back to that.
Sure.
But was it obvious from the video that Bradley Renfro was the person that came into the Holiday gas station?
Yes, Bradley Renfro and Dominic Johnson.
All right. Now, before the interview with Austin Barrett, you made contact with Bradley Renfro on November 30th of 2016, right?
Yes, sir.
Okay. And actually, another investigator contacted Renfro before that on November 26, 2016, correct?
Investigator call it, yes, sir.
Right. And was there anything significant about that contact in terms of the statements that he made about his involvement in this?
I would have to go back to the interviews that you're talking about specifically, but I remember investigator call at the time calling me after he was done talking with Bradley Renfro and Alyssa Bledsoe, and saying, I think we've got identified at least another player in your investigation.
Okay.
But to the specific statements that he made to investigator call that night, all I can remember off the top of my head is that it was clear that he was involved somehow.
Right, okay. Now, turning your attention to November 30th, was Renfro at the Wasilla Police Department on
Yes.
that day?
Yes, sir.
And was it for a different purpose, as far as the Wasilla Police Department having him there?
Yes.
And how did they know to contact you, or how did you become involved in the November 30th interview?
I was, obviously at this time, in November 30th, we're 2 weeks into this investigation. Bradley Renfro's name had already come up once, Alyssa Bloodstone's as well. We knew they were an item, boyfriend, girlfriend. And when my investigators and troopers that knew that I was working on this case overheard his name mentioned on a Wasilla PD call, Wasilla PD notified me that they were dealing with him, which is not uncommon.
And did you have an opportunity to interview Bradley Renfro on November 30th?
Yes, Sergeant Ingram and I interviewed Bradley.
And that it happened at the Wasilla Police Department?
It started at Wasilla PD interview room, and then it ended up out in the parking lot.
And this was recorded,
It was.
video and audio?
It started off being video and audio, and it ended up just being audio recorded.
Did the interview start with him lying about his participation in this?
Yes,
All right, and was it obvious to you that he was lying?
it was.
Similar to what Erick Almandinger did to you
Correct.
the first go-around?
Yeah, it was pretty obvious. And Bradley's mother was present for that interview, and I was basically straight up with both of them. I said he's being deceptive, and I confronted Bradley about being deceptive. And we started to get a little bit further, but come to find out he was apprehensive about talking to me in front of the cameras.
Now, eventually, during that interview, he did get into the incident, is that correct?
Yes,
All right. And as far as naming the other participants, did he name all the other participants?
he did.
All right. And who did he say was present during the, let's start out with the assault in the trailer?
Austin, Dominic, Erick, David, him.
All right. And just so we have a good record, Austin is Austin Barrett?
Austin Barrett, correct.
And
Dominic
he,
Johnson.
you also knew that he goes by another name, or he was?
Andrew is what his friends called him, but we had positively identified him as Austin Barrett, even though I think most of the folks in this case talked to him, referred to him, I should say, as Andrew. And we talked to him about that during his interview on December 7th.
And eventually, Renfro did talk to you about the assault that occurred in the camper trailer.
Correct.
He gave you his version.
He gave me a version.
Right, a version. And he put Austin Barrett in the trailer when the assault occurred, correct?
Yes.
Okay. Now, I believe he told you that it was Erick Almandinger that had decided to assault David Grunwald?
Yes.
And then, as the interview went on, did he also describe for you how the group put David Grunwald into the Bronco and took him to a different location?
Yes.
And during that portion, did he also describe all the people that were involved?
He did.
in
And
that?
I actually, if I remember correctly, during this interview, asked him to describe to me where everybody was seated in the Bronco. And he described that to me.
Right. And did he include defendant Austin Barrett in that description?
Yes.
And he said that Austin Barrett was in the back seat of the Bronco, correct?
Correct.
And then, as the interview progressed, and I know I'm not gonna play it or cover it in extreme detail, but as the interview progressed, did he also describe what happened at the Knick River Road location?
Yes.
And did he describe the participants in that incident?
Yes.
And who were the participants that he described?
Austin, Dominic, Erick, himself, and then, of course, David.
And then, obviously, this led to the murder. Did he describe how the murder happened?
If I remember correctly, he did.
Right. And then, after that, did he also talk about going to Devin Peterson's house and the Holiday gas station?
Yes.
And did he include Austin Barrett in the group of people that went to Devin Peterson's house?
Yes.
And did he tell you that Austin Barrett or Andrew was dropped off at Devin Peterson's house by the others?
Yes.
In other words, he didn't go to the location of the Bronco burning.
That's correct.
Right. And did Renfro, as far as the other information he provided, did Renfro admit that he was involved in the burning of the Bronco?
That was one of the first things that he actually admitted to. His exact words were, at worst thing I did, if I was, I don't want to quote myself now here, but he's basically words to the effect, at worst, I helped burn the Bronco. That was the beginning of where we started to actually unravel his lies that he had previously told me. So yes, he admitted to helping burn the Bronco. He lied about how they did it. He said they did it with alcohol. It turns out they did it with gas, but yes.
Right. And did Renfro, in this November 30th interview, did he ever waver as to who the participants were? Did he ever name some name that you weren't familiar, or did he always stick with the same people, Johnson, Barrett, Almandinger, and him?
Yeah, I don't remember him ever wavering.
Going a little bit later in time, let's talk about Dominic Johnson.
Sure.
As far as information you had on Dominic Johnson, you said his phone number was used to call the cab.
Yes.
He was contacted at the Palmer Car Store by troopers, correct?
It was the Wasilla cars, but yes.
Wasilla Cars.
Yes.
Right.
On Thanksgiving Day.
All right. Was there any more contact with him, or were there any other interviews attempted with him before December 2nd of 2016?
No interviews per se. There was some incidental contact with a different case, and I'm trying to remember if it was before or after that November 28th contact, but there wasn't any interviews done for sure.
All right. And is it fair to say that you and your team of investigators were trying to keep track of the whereabouts of the suspects during the course of the investigation?
Absolutely.
Was there some brief contemplation to have Renfro assist by doing a glass warrant against some of the others?
Yes.
And was it going to be against a particular person, do you remember, or a group, or if you recall?
It was a particular person, and I don't recall off the top of my head because it was never executed. We didn't actually follow that tactic through.
So it never panned out?
Correct.
Was there a reason why that never went forward?
Well, he wasn't completely forthcoming, and we ended up not needing that strategy to have to play itself out. So it wasn't something we felt that we were comfortable with continuing after we learned stuff that happened later on, like on December 2nd.
Now, I understand that Bradley Renfro was put up at the Valley Hotel on the evening of December 1st, correct?
He was. It was a call that I made based on a Palmer PD officer's request that they had to find somewhere to be for Bradley, and we needed to. I knew Bradley was somewhat cooperative based on my interview with him, my contact with him, and as a result, the state of Alaska paid for one night for Bradley to stay in the Valley Hotel.
And was there, I know that some investigators had contact with the group the morning after. Was this an intentional surveillance, or were there some investigators happened to be in the area the next morning?
No, I put those investigators in place for the very purpose of being able to identify who was going to be coming out of that hotel room at the Valley Hotel the morning of, because I received information that everybody was back with the group. And we, as a result, investigator called and saw Austin Barrett coming out of the Valley Hotel the night after or the morning of when we got that room for him. And so as a result, I made a text message or a phone call just to say, hey, I'm going to come by and I'm going to visit with you. We're going to talk about the case, and knowing that my presence there would cause them to leave the room. And so when they did, my investigators were there to see who left the room.
And as far as the observations, did you feel that it was important to document the the observed associations of the suspects during this time?
Yes, and this was December 2nd, so we're, what, 2.5 weeks into this case and working every day on it. So we had a decent handle on who would have been involved, and the fact that they were together again, and as we were applying pressure, was significant to me.
Okay. And so Austin Barrett left the hotel, then he came back, and then you placed the phone call?
Correct.
And then what happened after the phone call was placed to Renfro, I assume, was the phone call,
Correct.
right? Because he was the point of contact at that time.
Yes, sir.
Describe what happened and what the investigators observed.
Within about a minute or so after me saying I'm going to come across the street and I'm going to meet with you, everybody left the room, or I should say everybody that we observed leave the room, and that was Devin Peterson, Bradley, Austin, Dominic Johnson, and if my memory serves me correctly, Alyssa Bledsoe may have already also been there, and I feel like that's, she's one of the ones that was there that night, yeah.
All right. And I want to explore the chain of events on that day of December 2nd,
Sure.
2016 a little bit. Devin Peterson was in the group, correct?
Yes,
And was he interviewed on that day?
I interviewed him first.
All right. And did he give up information when you interviewed him?
Yes, ultimately,
And did he told you that Erick Almandinger had committed the murder?
he did.
And did he also talk about the group coming to his house afterward?
Yes,
And did he verify that Austin Barrett stayed at his house?
he did. That, yes.
All right. And I'm going to jump around a little bit. Before Austin Barrett's interview, there was also a search warrant of Devin Peterson's house, since we're on the subject of
Sure.
Devin Peterson, right?
Yeah.
There was a search warrant that was executed at his house on the 6th of December, was it?
Yep, 12/6.
The day before Austin Barrett's interview?
Correct.
And you were part of that search party?
Yes.
Was there something that you were primarily looking for?
Murder weapons.
And did it turn out that you did secure the weapons involved in this case?
Yes.
And remind us again, where were they located within the house?
In a backpack located, if I remember correctly, just inside of where, I think it's Devin's room, actually, inside of a black backpack.
All right. Now, but you just told us that Devin Peterson was interviewed by you on December 2nd.
That's correct.
And he gave up Almandinger.
He did.
But yet, he continued to possess the firearms at his house?
Yeah, and if I remember correctly, for the December 2nd interview, lied to me about where those guns were. He additionally lied to me again on December 6th when I interviewed him, and it was during the part about the weapons that I was interviewing him, and he was lying to me when Sergeant Ingram and the rest of the investigators found the guns, literally as I was asking him about the guns.
All right.
And he said they were gone.
And is it fair to say there was a tremendous amount of lying by almost everybody involved in this case?
That's correct.
All right. Now, in addition to the guns, was there some property associated with Austin Barrett found in the vicinity of the guns?
Yes, we found a a knit cap with the Ouija logo on it.
And how did you know that that was associated with Austin?
We had some social media records, pictures on Facebook, if I remember correctly, possibly Snapchat, but nonetheless, social media pictures with him wearing the hat. And I think in our interview, we ended up talking to him about that, and he admitted to it.
And was there a wallet and some identification for him located too?
Yes.
And that was documented through photographs?
Yes.
And what do you mean by located where?
I don't know.
Exactly where?
I wasn't part of the search. I was interviewing Devin Peterson at that point. I just remember being advised that we located not only the guns, but the hat and a wallet belonging to Austin.
So Officer Ingram's gonna testify to the exact location?
He may have some more information about where that was, but you reviewed the photographs, Sergeant Wegson?
In the past, not recently.
Right,
Yes.
and the background as far as I think it was like a purple sheet or something on the bed, was the background similar for the wallet and identification as for the guns and the backpack?
Oh, yeah.
And
that's
the rest
right.
of the items?
Basically doing the search, and it's not a large residence. We're talking about if I had to estimate, maybe it's 700 or 800 square feet. It's a small house. And so we're kind of consolidating all of the evidence kind of in the middle of the room on a sofa sleeper /couch/coffee table area.
Now, did you learn through your investigation whether there was a relationship between Austin Barrett and Devin Peterson? I'm not talking about, sexual relationship, obviously.
Sure.
I'm just talking about a relationship as far as them being friends.
Yes, I established that.
Okay. And did it turn out, per their own statements, did it turn out that they were very good friends?
Mhm. Yeah, and I don't remember exactly what Austin said, but he considered Devin family, if I remember correctly.
Now, did some of the investigators, and again, this goes to information you had before you talked to Austin Barrett on December 7th, did some of the investigators go back after the search and talk to Alana Peterson, Devin Peterson's mother?
Yes.
And did the interview concern the events of the night of November 13th, 2016?
Yes.
Did Alana Peterson verify that the group came to her house that evening?
Yes,
And did she verify that Austin Barrett was dropped off there that evening?
she did.
And did she verify that Austin Barrett slept in a Dodge Neon outside without any heat that evening?
Yeah, and I don't think at the time she knew that. I think that was something that she discovered the next morning after she went outside and was surprised to still see him there. But yes, she confirmed that.
And did she also describe some unusual behavior on the part of Austin Barrett while he was at her house?
I remember correctly, she was saying that he was nervous or skittish, checking the window that faced the street that they lived on, K Lake Road, down the driveway and to the observable portion, at least, of the street that's out there in front of the house when a car would drive by.
And no, I'm going to bounce back to December 2nd. Devin Peterson, he gave up Erick Almandinger as the shooter. I think he said that Erick Almandinger told him that he shot David
Devin
Grunwald.
told me that Eric whispered to him that night when they came to his house that Eric told him that he had killed David Grunwald.
All right. And did he mention the others in the group that came to his house?
I'm sure he did, but I don't remember in which particular portion of the interview that he told us that.
So his interview, I mean, I know you said that he did continue to lie about the guns, correct?
He lied that night. He lied the day of December 6th. Yeah, the theme with Devin Peterson was lie, get confronted with evidence, come clean. Lie, get confronted with evidence, come clean. And that was kind of his theme. And so with the evidence I had at the time, I was able to confront him on both the December 2nd and December 6th interviews. And when confronted, did at least partially tell the truth. So,
All right.
but it wasn't until he was confronted.
Now, with Erick Almandinger, after you talked to Peterson, at that point, were you quite certain that he was a suspect in this case?
That Eric was?
Yes.
Yes.
Okay. And after the information about Dominic Johnson, that his phone had called the cab, were you certain that Dominic Johnson was a suspect in the case?
Yes.
And then when you had the photograph of Renfro and his statement that he was there for all the events, were you quite sure that he was a suspect in the case?
Yes.
And same thing with Austin Barrett, after you observed him with the group and after Alana Peterson had indicated that he came to her house and stayed at her house in the car, were you quite certain that he was a suspect in this particular case?
Yes, sir.
All right. Now, going back to the chain of events on December 2nd, did anything happen between the time Devin Peterson was interviewed and when you had contact with John Mark Peterson and Dominic Johnson? Anything of significance happen during the day that is noteworthy for this hearing or not?
The most noteworthy thing is the fact that John Mark and Dominic had a chat and we went out and found David. That's what sticks out in my mind, obviously, and I'm not sure if there's something else that.
Okay, and then just touching briefly on that, there obviously was an agreement with Dominic Johnson, correct?
Yes.
And can you describe what you remember to be the agreement on that day?
Sure. Dominic wasn't going to be arrested. He wasn't going to make a statement, but he was going to show us where David was.
And he did not make any statements during that time?
No.
I mean, he made a
Correct.
few, correct?
Incidental statements while we were out searching, but it wasn't in an interview. They were almost spontaneous utterances while we were out looking. Things like, well, I don't remember us being this close. I don't remember the river being that far away. This doesn't look like the right area. Those sorts of statements, but nothing like a formal interview.
All right. Now, and I'm not going to get into all the details, you know, the event of you finding David's body's been pretty well documented through reports and in the previous trials, but you found the body in a wooded area off of Knik River Road, correct?
Yes, sir.
And this was with some assistance from Dominic Johnson.
Yes.
And as far as what happened with him, Dominic Johnson, was he arrested after this or not?
No, he was allowed to leave. He left with John Martin Peterson.
All right, but let me ask you, just the very act, I mean, there were no agreements that we couldn't use, the very act that he took you to that location as evidence against him, correct?
No, that's correct.
All right, and I don't know if they hadn't contemplated that or whether it just wasn't discussed, correct?
Yeah, not to my knowledge.
All right. Now, because Dominic Johnson was able to take you to that general area before you found the specific spot, did that confirm to you that Dominic Johnson was involved in this?
Yes.
Then, December 2nd was a long day, correct?
It was.
In terms of, it perhaps was the longest day of the investigation, right?
I would agree, yes.
Okay. Did you make contact with Erick Almandinger on December 2nd, 2016?
I did.
And the purpose of that being?
To place him under arrest and interview him for the murder of David Grunwald.
And you felt like you certainly had enough evidence to arrest him
I
on
did.
that day?
Yes, sir.
Now, there was an interview of Erick Almandinger
Yep.
at the Post,
Yes, sir.
recorded,
Recorded video and audio.
right, and he had some family members there at various times?
Yeah, he had, it seems like his whole family there at some point, but yeah, his mother, his father, and his grandmother.
Now,
on his
did
death.
that interview have some similarities with Renfro's interview and Peterson's interview? Did it have some general similarities?
There were some overlapping sections for sure, yes.
Okay. I guess I'm talking about like hesitation to speak at first or not telling the complete truth at first.
Well, those are definitely themes throughout all of the interviews. But as far as the players, those obviously never changed. That sequence of events didn't change. We had established that everything started in the trailer, that it led to the Bronco, that led to Knik River Road, that led to David's murder, that led to Devin Peterson's house, and that led to Sites Road.
And in that interview, did Erick Almandinger name the same participants as Renfro named in his November 30th interview?
Yes.
And again, who were those people? And
Austin, Barrett, Bradley Renfro, himself, Erick Almandinger, Dominic Johnson, and then, of course, he also identified Devin Peterson as somebody who helped out but wasn't present for the actual murder.
All right. Now, one of the more glaring things about the interview was that he had named two different people as the shooter.
He
At
did.
various parts in the interview,
He did.
correct?
Mhm.
All right. And obviously that's a concern. Was that a concern to you that he gave two different people as the shooter?
Yeah, that was a pretty big concern. That's a red flag, obviously, within a murder interview, is to have somebody tell you that one person did it, and then a few minutes later, or 15 or whatever minutes later it was, tell me a completely different person pulled the trigger. So
Did he at first acknowledge that he was the shooter in this case?
Erick?
Right.
No, Erick never acknowledged that he was the killer in this case.
So which people did he name as the shooters? And-
Austin and Dominic.
All right. And in terms of order in the interview, did he first say that it was Dominic Johnson that killed David Grunwald?
Yeah, I believe he did, and then asked for a countdown and then said Austin.
Right. And now the countdown, that was after his mother appeared at the interview?
Correct. She wasn't present for when he had named Dominic. She'd come in between that statement and the statement that he made about Austin.
All right. So you have, so at this point, up to that point in time when he named Dominic, you had Devin Peterson tell you that it was Erick Almandinger, because that Erick told Devin that he was the killer or the shooter, right?
That's correct.
Then you had Renfro in his November 30th interview name Erick Almandinger as the shooter, correct?
Correct.
Then you had Erick Almandinger named Dominic Johnson as the shooter in the first part of the December 6th interview.
Correct.
And then when his mother came, describe the countdown again.
I was confused about the countdown as well. It was essentially Erick just wanted to, he asked for, give me a countdown, and we both, his mom and I, were confused what he meant, and then he said, well, just say 3, 2, 1, and I'll tell you who it was. And so I guess I inferred it was kind of like his version of just ripping off the Band-Aid, and he just wanted that countdown in order to facilitate him telling us who did it.
Right. And at that point, he named this defendant, Austin Barrett, as the shooter. Is that right?
That's right.
Did he elaborate anymore, or he just said it was Andrew and then left it at that?
Well, I asked him, obviously, why in the world would he name Dominic and then say Austin or Andrew, and he indicated that Dominic was the one person that was in the group that he didn't consider family, so it was easier to throw him under the bus than it was to throw Austin under the bus. And I'm using my own words there, obviously. But that he didn't want to implicate Andrew as quickly or as easily as he would with Dominic, because he considered Austin family.
All right. So now that during the investigation you had people name 3 different people as the shooter, I mean, there wasn't much certainty at that point as to who pulled the trigger. Is that correct?
There wasn't. No.
All right.
Definitively not.
Scientifically, was it pretty well established through the scene investigation and through the crime lab that it was one shot that was fired, and certainly one shot that was fired into David?
Correct.
Okay. Now, which leads us to Austin Barrett. Did anything else happen between the interview of Erick Almandinger on the 2nd of December and his subsequent arrest after the interview, and the interview with Austin Barrett on December 7th?
Well, so we went from the 2nd to the 7th. So
Right.
yeah, the 6th we had the K Lake Road search warrant with Devin Peterson, and then finding Austin's wallet and the Ouija cap, and then I think some other stolen property. But nothing else sticks out to me right now.
Right. And so before the interview with Austin Barrett, let me just talk about your impressions, because it may make a difference in the analysis of this interview. Were you confident that you had the right people, as far as the people involved in this were Erick Almandinger, for one?
Mm-hmm. Yes.
Dominic Johnson?
Yes.
And you never tried to do a second crack at Dominic Johnson, like try to go back to his attorney and see if he would make a statement?
I don't remember.
Or did you just leave it as it was?
I think I just left it as it was. Yeah.
And were you extremely confident that Bradley Renfro was involved in this?
Yes.
And based both on his statements and the videotape and such?
Yes. Correct.
And Austin Barrett also?
Yes.
And before Austin Barrett's interview, was it your feeling that you could have arrested well, Almandinger was already arrested.
Sure.
Was it your feeling that you could have arrested all of them for the murder based on the accomplice liability statute?
Yes.
Now, bigger picture, you've worked other cases before, is that correct?
Yes, sir.
You've worked with prosecutors before, is that correct?
Yes, sir.
Is it a common understanding nowadays between police and prosecutors that it's preferable to try to do an interview with the suspect before making the final arrest? I mean, is that sort of
That's the idea.
standard
Absolutely.
logic when
Yes.
you do investigations?
Absolutely. Get their side of the story.
Okay. Now, so before December 7th, 2016, we know from what you've just told us, you didn't have Austin Barrett's side of the story yet, correct?
That's correct. It did not.
All right. And was it just timing that, that he was sort of the last man to be to be confronted with this?
Somebody has to be last, and in this case, it just worked out that way.
Okay. Now, we're not talking, not a lot of days.
No.
Renfro was interviewed November 30th, and Almandinger was interviewed
Well,
5 days.
Right.
5 days before
Right.
Barrett was interviewed. Another thing I have to talk to you about before we get into the interview, and that is, I know that you had Sergeant Ingram, and who else go to contact Austin Barrett?
Sergeant Ingram transported him back, but I think Investigator Decor might have also been there, been present when Austin was contacted at the Wasilla Fishhook Food Mart.
All right.
I can't recall.
And they brought him back to the trooper post
Yes, sir.
here in Palmer.
Correct.
Right. Now, I want to talk to you a little bit about information sharing, as we have in previous hearings, amongst the investigators involved in this investigation. What was your, as far as you being in charge of the investigation, did you feel that it was important for all the investigators involved to be apprised of developments as they developed in this particular case?
Yes.
So when Decur and Ingram went out to the Food Mart
Yeah.
store,
Wasilla Fish Food Mart.
yeah, were they aware of all the information that you and I just put on the record during this hearing?
Yes, and then some. I mean, Sergeant Ingram, Investigator Decor, now Sergeant Dunford, then Investigator Dunford, Investigator Ballesteros, Investigator Cult. We talked daily, multiple times a day, throughout this entire
All
investigation.
right, and sometimes when I listened to the interviews, I heard like phones pinging, like messages coming through. Did you communicate via phone also, text messages and such?
Yes, in some cases, sure.
When it was urgent to
Yeah.
communicate?
Sure. Mhm.
Okay. And in terms of, in addition to briefings, like personal familiarity with the events and Austin Barrett, and information pointing to Austin Barrett before the December 7th contact by Sergeant Ingram and Investigator Decur, was Sergeant Ingram one of the people that were at the K-Lake address when the murder weapon and the assault weapon were located?
Yes, sir.
All right. And was he also one of the participants in the interview with Alana Peterson, where she had verified that Austin Barrett was part of the group that came to her house after the murder and was dropped off?
Yes.
Okay. So he had personal knowledge of that, is that correct?
Correct.
All right. And did he also have knowledge through you of, obviously, that Dominic Johnson led you to the general area of David's body, correct?
Yes.
And did Investigator Ingram and Sergeant Ingram and Investigator Decur also know that Erick Almandinger had admitted participating in the event and had named both Dominic Johnson and Austin Barrett as the shooters at different times during the interview?
Yes.
So they were equipped with all that information. So lead us into December 7th, 2016, and what led up to the contact between Sergeant Ingram, Investigator Decur, and Defendant Austin Barrett?
Well, like I said, we knew he needed to be interviewed, wanted to get his side of the story. We had plenty of information leading us to him on this case. And so we learned that he was going to go to the Wasilla Fishhook Food Mart, and so we just ended up being there so that when he showed up, we could chat with him.
And then you were not present when that happened, right?
I was not.
But what is your understanding of that, of how that went down?
Basically, he shows up in a car with other folks, not by himself, but in a car of other people, and I can't tell you who was also in the car with him. Sergeant Ingram identifies himself, detains him, and transports him back to Palmer Post.
And that was recorded also?
Yes, sir.
And there wasn't any, from what I understand, there wasn't any substantive discussion about the case during the transport, correct?
Correct.
And was that intentional, or was that just?
That's just pretty normal. We're going to chat about the case when we get back to the office where, you know, it's a little bit more, it's a more controlled environment with talking with somebody in the car. Number one, it's only you there, and if your recorder malfunctions, it's just you. Second of all, you got road noise and all sorts of other stuff, so
Right.
it's a more controlled environment to do it at
Right.
post.
But we're acknowledging that he was detained for purposes of being taken to the station,
Yeah.
the post, and being interviewed, right?
Yes, sir.
Okay. I mean, I guess he could have been asked politely to show up at the station via phone call or whatnot, but it was a call on your part, or on the part of you and the other investigators to find him and detain him.
Yes.
And is it fair to say that at that point, the investigation was wrapping up to a degree?
To a degree, sure. There were still some question marks left out there, but some of them were going to be answered by Austin in this interview,
All right.
if he was willing to speak with us. And we knew that going into this that he had his right to not. But still, there was the attempt to make, at least, to check the block to say that we tried to speak with him and get his side of the story.
All right, and I'm going to also talk to you about some dates after December 7th. Now, in his interview, Austin Barrett talks about the going to grand jury, and you recall that because Erick Almandinger was arrested on December 2nd, we had 10 days to
Yes.
do the grand jury, and we had scheduled grand jury for Thursday, December 8th.
Correct.
To present this case, right? And that's
Yes.
what Austin Barrett was talking in the transcript about. right?
Yes, I believe so. Mhm.
Okay. So he was aware that he was going to be called to grand jury on the 8th, right?
Yes.
Now, with this interview, was there planning or strategizing as to how you would approach the interview with Austin Barrett? Or did you feel it was best just to have him come in, take his temperature, so to speak, and decide how to go from there?
That's basically how I run all of the interviews. So the latter is what you mentioned is kind of more like what we were expecting. Get him inside, read him his Miranda rights, let him know what his rights are, tell him why we want to talk to him. Obviously, he knows, but we always tell him. And then see where we go from there. But as far as the planning of the interview, no, it was no strategy necessarily.
All right. And as far as presumptions, what presumptions you had in your mind, did you presume that there was some communications among the defendants before this December 7th interview, as far as them communicating, texting,
Oh, absolutely.
whatnot, through social media or otherwise?
Absolutely.
All right. And therefore, did you also presume that Austin Barrett had knowledge of certain things, such as that Erick Almandinger was taken out of circulation?
Yes.
Before the interview? Did you presume that he also likely knew that Bradley Renfro had been interviewed?
Yes.
Anything else that you can think of?
Well, I knew that after the December 2nd arrest of Erick Almandinger and the charging documents that went out, although I didn't use Austin's name in there, I used his initials, and I didn't use his correct age. I knew that he knew that, the charging documents were copied and pasted into the Anchorage Daily News.
Mm.
So AB, 16 years of age, everybody knew it was Austin Barrett, even though he was 19.
And you also presumed that he knew that David's body was found by you, correct?
Oh, absolutely.
Okay. So, in other words, what I'm getting at is it doesn't seem like there were too many surprises that could be pulled on Austin Barrett at that point, right?
No, this was the part of the story where in fact, I think I say during this, and I've had to refer to the transcript to get the exact words, but basically this is your opportunity to tell your side of the story. I don't necessarily need you to say anything. It's the ball's in your court.
No, and of course you still have that, I guess we can call it a loose end, that the others, because you talk a little bit about others being interviewed in the interview with Austin. The others gave you 3 different names as the shooter, is that correct?
Yes.
Did you have some hope that maybe that could be clarified by Austin Barrett? I mean, I don't know if it would carry the day as far as figuring out who the shooter was, but maybe if, X number of people say one thing and then X number of people say the other, we can make some
Right.
presumptions.
Really, at this point, we have a tiebreaker, if you want to call it such, between Erick saying that Dominic and Austin did it, and you have Bradley saying just Erick did it. And then if you want to count Devin, who was he wasn't there, but he got told, he says Erick does it. So, yeah, Austin's already been implicated as the trigger puller. So there's that part of it. And then there's also the part, like, let's see if we can get a theme on what the participants of this say who did it.
And does it ever hurt to get more information about a case?
Not to my knowledge.
Now, the way I understand the interview, there were basically two segments. And correct me if I'm wrong, but the first part was at the trooper post with you and Austin Barrett and Sergeant Mike Ingram, right?
That's correct.
Right. And then the second part was at the DA's office, correct?
Yes, sir.
Okay. And I don't know, do you have a pretty good memory of the first part and the second part?
I have a memory of the them happening. I have some details that stick out, but it's not. I don't have it, verbatim in my head.
Right, and it's not. In this day and age, we know that all videos are audio recorded. We know that a lot of them are video recorded. Right. We know that we generate transcripts. I mean, you had one of your employees do transcripts of all the interviews, right?
Yes, sir.
Okay, and that's very helpful. So it's not like the old days where perhaps things weren't recorded in the court and the defense counsel relying on the officer's rendition of the interview.
Right.
I mean,
Any discrepancy that I may come up with is going to be able to be cleared up with one of those three medias, either the audio, the video, or the transcript, which the transcript's obviously a product of the audio and video, but still.
Right. And let's talk about the basics, some of the basics. Austin Barrett knew why he was there, right?
Yep.
I mean, it wasn't vague about what he was there for, right?
That's correct.
And were the handcuffs removed when he was at the post?
Yes.
And you gave him his Miranda rights, correct?
I did.
Now, when we're talking about Austin Barrett as compared to the other defendants in this case, he is an adult.
He's
correct?
19 at the time,
All
I
right.
believe, yes.
And therefore, there are no other special requirements to have parents there, aunts or uncles, just him and the Miranda rights, right?
That's it.
And did you give him the standard Miranda rights?
I did.
And he was fully aware of what you wanted to interview him about?
Yes.
And the final question, the Miranda rights, is are you willing to make a statement, right?
Yeah, do you
And-
wish to talk to me now?
And what was his response to the Miranda rights?
I'll answer your questions.
Now, during the interview at the Post, it seems with a lot of these interviews, it almost seems like you and/or the other investigators are doing more talking than the people being interviewed, right?
At least at the beginning, for sure.
It seems like there was a high degree of hesitation on the part of all of them to provide information to the troopers, correct?
Sure. I would love it to be like a victim interview when I go in and I say, tell me what happened, and they just tell me what happened. But in almost every case, it's not like that. Mm-hmm. There's some foundation that I have to lay, because again, the theme, not just with this case, but in others in my past, it's been my experience that if somebody doesn't know they're caught, they'll likely withhold information. And so I do lay a little bit of a foundation, and that manifests itself as me doing a little bit more talking than them.
Okay. And with Austin Barrett, was there a degree of hesitation as there was with some of the other suspects?
Yes.
Right. And were there considerable discussions about the pros and cons of him making a statement?
Yeah, I think so, yeah, from what I remember.
All right. Is it fair to say at the Post you were urging him to make a statement?
I think my exact words were like, talk or don't talk. You plead the fifth, I think is my exact words. I have what I need. I think it's going to be in your best interest to tell your side of the story, because other people are telling your side of the story right now. But if you don't want to, you don't have to.
Right. And in terms of, like, we know in Alaska, police officers can use deception. I mean, you can't use force, obviously, or physical force, but you can use deception in interviews. But when you told them that other people had talked, you were telling the truth, correct?
I was.
Because at that point, Erick Almandinger gave a fairly lengthy statement.
Mm-hmm. That's
and
correct.
Bradley Renfro gave a fairly lengthy statement.
Yes, sir.
Devin Peterson gave a statement.
Yes, sir.
And of course, Dominic Johnson took you to the general location
Yes.
of the body, right?
Correct.
And I'm just talking about the main participants, I'm not talking about people like Alana Peterson, who also gave you a statement implicating Austin Barrett
Right.
in the event. At the post, just from your recollection, what did you feel was Austin Barrett's major concern as far as making a statement or not making a statement? Even though, I mean, I guess we should clarify, he said he would agree to answer your questions, right?
Yeah, absolutely.
But then he kind of hemmed and hawed and didn't know whether what he should say. And the discussions took you various different places, right?
Right. The underlying theme is he was concerned. When I say he's concerned, I think he used the term scared about Erick and the other participants and whether or not what they were going to think, what they were going to hear about what he told us.
Right. And he described in detail why he was scared about Erick Almandinger, correct?
Yeah, I think he said something to the effect that Erick had told him that he would kill him, kill his family. He felt like, I think at one point he just saw Erick kill David. So he was, in his mind, legitimately concerned that Erick could do the same thing to him. That was his apprehension.
And he also described some incident at the trap house where Erick was on meth and said he had bullets for people and
Briefly,
whatnot,
correct.
right?
Yes.
Okay. And then did he also express some concerns about, like, his statement being made public, and did he have questions about whether his statement could be kept confidential?
Yes.
All right. And is it fair to say that it went round and round and round and round for a while?
For a little bit, yeah, it did.
All right. And then at some point, did he express that maybe he wants to go home and meditate and pray and come back the following day and whatnot?
I remember him saying he wanted to pray on it. I don't remember him necessarily saying he wanted to go home, but I do remember him saying that he would like to pray on it. And I think my response was, it's now December 7th. This happened November 13th. What is praying on it now, the night I'm actually talking to you, going to do past what you've been doing for the last 3.5 weeks?
Yeah.
Or 3 weeks, I should say.
All right. And just like the other, as far as the other topics, general topics, we could play it eventually, but the other general topics that were covered, I mean, it was basically him saying that he was afraid, and that was an impediment to him making a full statement to you. He was afraid of the publicity, like him, being talked about as one of the participants and whatnot. And then the discussion ranged to things like his future, what do you want to do, that this could be a instrumental point in deciding what his future would be, and those kind of things.
Yeah, we talked about a lot of stuff. That's correct. Yep.
Okay. And then, is it fair to say that while he did give you some tidbits at the post, there was not really a full substantive interview at the post?
That's correct.
All right.
Yep.
Because he was, hesitant to?
He was a little hesitant. I think he made mention of the cameras, which are clearly visible at our interview room. It's not like they're hidden. You can see the camera, and it's looking right at you. And if I remember correctly, it was my suggestion that we maybe move the interview over to your office and speak with you about it.
All right. And let me talk a little bit about that and the background of that. Before you had your interaction with Erick Almandinger, did you have any previous contact with him?
With Erick?
Yeah.
No.
And before you had any contact with Bradley Renfro, as it relates to this investigation, do you have any prior contact with him?
No.
How about Devin Peterson?
No.
How about Dominic Johnson?
Also no.
Okay. How about Austin Barrett? Had you ever investigated him or
I had not.
had any knowledge about his background? Or
All of them were unfamiliar to me, including Austin.
all right. And were there some discussions, in addition to the information sharing among the investigators, were there some discussions between investigators and the prosecutor's office during the course of this investigation?
Absolutely.
All right. And is it fair to say that the investigators and the prosecutors were still being somewhat open-minded about the notion that maybe one of the people would tell the truth and maybe could become a witness? Like maybe there's one person that's less worse than the others?
Sure, absolutely. That was always the hope, I guess.
All right. Now, and when Austin Barrett was picked up on December 7th, did you know exactly what his attitude would be, or what his answers would be or anything like that?
No idea.
All right. Now, I noticed that the Post, Austin did have some concerns about, is he facing life in prison, I think was one of his concerns. And obviously, you couldn't answer that question because that would involve an extreme amount of speculation, right?
Right, and that's something I try to steer away from as procedurally for me personally. Somebody asked me what the penalty is going to be for this particular offense. I try to do what I can to just tell them that I have no control over that, that they're going to be held responsible in some way, shape, or form, but I can't tell you what you're looking at now. We're way too early in this game.
All right. And during this, call it the pre-interview at the Post, there was discussion about grand jury, the nature of grand jury, the purpose of grand jury and such, right?
Yes.
And which leads us to the point where you suggested that maybe Austin Barrett should talk to the DA. I want to talk about the factors that were in your mind. You knew that we had grand jury the next day, right?
Right.
I mean, that this was happening fairly quickly. And are you fairly confident that, because you had discussed grand jury and the role of the grand jury, the role of the DA, the fact that there are no defense attorneys there, are you fairly confident that Austin Barrett knew that the DA would have a high degree of discretion in deciding who would be a witness, who would be on the indictment, things of that nature?
That's correct, far more than I would.
Okay. And when that issue was raised with Austin Barrett, was there some enthusiasm on his part as far as actually having myself involved in that in the interview, in that conversation?
I'd say so, yes.
And I mean, eventually one of you asked him whether he would be willing to give an interview with me being present, correct?
Correct. That was, yep.
And that he agreed to that?
Yes.
Okay. And the interview will reveal that it took some time for you and Sergeant Ingram to contact me and coordinate, but eventually you did make it to the DA's office?
Yes, sir.
And was that car, walking, do you remember?
Oh, it was cold out, so we hopped into our cars, I think Sergeant Ingram, and in fact, we all might have come over in one vehicle. Either way, we drove over.
And was there handcuffs or not?
I don't remember handcuffs being involved in that. I mean, it's only across the street, but no, I don't remember handcuffs being involved in that. But I could be wrong.
All right.
But I don't remember that happening. I'm fairly certain. In fact, I'm fairly certain I don't remember taking off handcuffs when we got to your office, and why we would put them on for just across the street doesn't make sense. So I'm going to say they weren't involved in that second transport.
All right. Now, you've had some interviews where people just rolled over, right?
Some.
Okay.
For you.
And then you've had some interviews where, I don't know, I call it, where the people being interviewed play hardball, right?
Sure.
As far as like the people involved here, like Erick Almandinger, Bradley Renfro, how would you describe their contacts in interviews? Were they, and I guess I'm getting to the court cases that say that people's contact with police officers or familiarity with law enforcement or participation in other criminal events may affect the way people interact with cops or act during interviews.
Sure.
So were they rolling over on you, or were they putting up obstacles during your investigation?
No, each and every time they were putting up obstacles.
Okay. And then, of course, you were privy later to some of their social media where they talk about, where their opinions about police officers become very evident. Right?
Oh, yeah, absolutely.
Okay, so is it fair to say that none of these suspects were fond of police
And that's correct.
or the criminal justice system?
And that's correct.
Okay. Now, so Austin Barrett, what do you remember about the interview at the DA's office?
I remember starting it off, I think you led with, again, telling him he didn't have to speak with us, that he's not got a lot of puzzle pieces that we don't already have, that we would like to hear his side of the story, that you explained in great detail and depth that if he didn't want to talk, he didn't have to. So that's what I remember about the beginning stages, at least.
Okay. And was it, I think it was conveyed to Austin Barrett that we were already suspicious of their statements, right?
Correct.
And that we had inconsistent statements from various individuals, right?
Right.
And then, do you also recall it being conveyed to Austin Barrett specifically that this notion that he wasn't involved or that he was scared, that we were very suspicious of that because of his continued associations with the others, even leading up to a few days before his interview?
Correct. Yep.
Okay. And then ultimately, did Austin Barrett decide to make a statement at the DA's office?
He did.
All right. And in terms of like things that the courts, the court cases talk about, the use of force or coercion or keeping somebody from the bathroom or keeping somebody from food, that kind of thing. This interview was what, late afternoon, early evening, is that correct?
Yes, sir. Yep.
Okay. And describe the setting of the interview,
How's
because
the
that's always important.
Sure. This is a conference room at the DA's office here in Palmer. We were just sitting around a large table. The lights are on. It's we had the room to ourselves, so it was just us four. Four. And he was sitting on one side of the table with you. I was sitting on the other side of the table, if I remember, with Sergeant Ingram. And it was fairly cordial. It wasn't a difficult process. I think we took a break in the middle somewhere, used the restroom, but it wasn't what you would stereotypically see on TV as far as an interview goes. It was just in the conference room at your office.
All right, and things like yelling or pounding fists on the table, was any of that part of the interview?
No, there were no raised voices. There were no fist pounding.
Okay, and do you feel like that it was made clear to Austin Barrett that grand jury was going to happen the next day? We could do it with his interview, without his interview, that this was his opportunity to make a statement if he wanted to make a statement?
Yes, sir.
All right, but were we also pretty clear that we didn't want to continue it for another day because grand jury was the next day?
Right.
There wasn't going to be another day.
There wasn't.
Okay. Now, some of the cases distinguish between confessions and simply admissions or false exculpatory statements. I mean, there's a lot of different ways to, as far as what resulted from the interview. A confession would be an acknowledgement that he had the intent to commit the crimes and that he committed them as the principal or he assisted. That's not what resulted from this interview, is that correct?
I would say that's correct.
Okay, what was born out of that interview, was it pretty similar to what defendant Bradley Renfro presented to you on November 30th?
Yes.
Okay, and what was the gist of Austin Barrett's statement?
That he was present, that Erick was the shooter, that he stayed at Devon's afterwards because he didn't want to have anything to do with the rest of this. He claimed he didn't want to have anything to do with it to begin with. Nonetheless, he admitted to his portion, the involvement of his portion.
Okay. Now, he never acknowledged being one of the beaters, correct?
That's correct. I think he's placed himself on the bed in the front of the travel trailer with Bradley Renfro when the beating was happening.
All right, and he never acknowledged that he was a shooter, correct?
That's correct.
Okay, but he did acknowledge that he was in the camper trailer when the beating occurred?
Correct.
That he was in the Bronco during the transport of David to the Knick River Road?
That's correct.
And that he walked from the Bronco into the woods and was present when David Grunwald was killed?
Correct.
Okay. As far as like similarities between his interview and Bradley Renfro's, was it the same in that both of them blamed everything on Erick Almandinger and said that they went along because they were scared of Erick Almandinger?
Yeah, for the most part, I think so, yeah.
Now, do you remember how long the interview was at the DA's office?
Don't. I want to say probably an hour, maybe a little bit more even.
And was there some time spent during this interview, talking about whether he would testify grand jury too, because we needed to know whether he was gonna testify or not.
Sure.
Do you recall some time being spent on that?
Yeah, I mean, it was the next day, and whether he's obviously got a Fifth Amendment right to not talk at grand jury.
Yeah.
I think there was some discussion about that for sure.
But do you remember whether he made that final decision?
I don't remember what his decision was on that. No.
Whether there were some discussions that maybe he had conversations with his father?
I do remember that he wanted to chat with Dad about it. But
You know-
I don't remember what he ultimately decided.
You know, in terms of whether he was willing to give a statement to the police, do you recall, like in the beginning, at the trooper post, he said something like his intent was to contact you guys eventually?
Right.
Because he talked to his dad urged him to make
For
a
himself,
statement,
right.
and then he said he was gonna contact you eventually, but then you ended up detaining him first.
Right.
You recall that?
Yes.
And after the interview, what happened with him?
Sergeant Ingram took him somewhere, and I don't know where right off the top of my head, but we gave him a ride home, or whatever he was calling home at the time.
Okay. So to the location of his choice, right?
Right,
I
which
think
is-
It might have been Devin Peterson's
It could have
house.
been. I can't recall off the top of my head, but that sounds about right, yeah.
And, I mean, do you feel that Austin Barrett was forced in any way to make this statement?
No.
Where he blames everything on Erick Almandinger, basically?
Absolutely not.
Now, were you involved in the other criminal investigations involving Austin Barrett before he made this statement?
No.
And,
You're talking about not this case,
right.
the other cases.
Right, and this goes to like, what may be his mindset as it comes to interactions with law enforcement?
No, I knew after he became involved in this case that those cases existed historically. I did not know, or nor had I had any involvement in them prior to this case.
Right,
And
But-
that's the burglaries and the
Right.
thefts and so forth?
right. So did you have a general knowledge that he was a suspect in a kidnapping / robbery where they had lured a guy to the Jasper house and under the auspices of him having sex with a young female, and then he ended up getting robbed?
Yes.
Okay. And you were aware that he was interviewed by troopers, so like.
You are? Yeah, absolutely.
He wasn't a newbie as to contact with troopers and being subject of interviews.
I remember that case happening. I just didn't have any involvement in it.
All right. And then also, there was some documentation through photographs that he had a stolen watch on him,
Right.
which was associated with Dominic Johnson's grandfather's burglary. And I think, in fact, there was some discussion about that at the trooper post in the interview.
Right. I think we showed him some pictures, slid him across the table of color photos of him wearing a watch that he had posted on Facebook or Snapchat that was confirmed to be stolen from Bob Carlson's place.
All right. And the case where he was present when Frank Woodford was killed, that happened before the David Grunwald
That's correct.
murder, correct?
That is correct.
Okay. And you're aware that he was a witness / suspect to that?
He was one of 3 people that were inside of a room when one person died. So yeah, there were only 2 people that lived through that incident, and he was one of them.
And then, talking about end results, so when we got to grand jury, Austin Barrett decided not to testify, correct?
If I remember correctly, yes.
All right. And all those decisions were made in the hallway. We were notified of those decisions in the hallway. Therefore we didn't call
Right.
people who didn't want to testify
Right.
to grand jury. Although, were you aware that Austin Barrett did testify in grand jury on the Woodford case?
If I remember correctly, yeah, I think we did
Because
call him.
you ended up
I-
being involved in that case, right?
Yeah, that one we went back in time and gathered more evidence that wasn't available to us at the time. And through interviews and other evidence, we were able to make a case against Damian Peterson for the death of Frankie Woodford.
And
That's
can
correct.
you remind me, was that, his testimony at grand jury, was that after his December 7th interview and after his invocation of his rights at the grand jury in the Grunwald case?
It would have had to have been because we put the Frankie case on hold while we took care of this case.
Okay.
Because we knew about it, it existed, but we had, only run one big case at a time out of the office we have, and this one was taking priority, and Frankie's was older.
So is it fair to say that even after the December 7th interview and after he decided not to testify at grand jury, the lines of communication with him were still open through counsel or otherwise?
Correct.
And then he ended up testifying at the Woodford case?
Correct, and I think we all had an appointment with him and his attorney, Mr. Howard, and later on in life as well, after his arrest, sorry.
Those are the questions I had for Sergeant Wilson.
Okay. You need a quick recess, Mr. Howard?
Only
Howard.
the court does. I'm trying to maximize, I think we're gonna be very close to not, I don't wanna run out of time. I'm ready to go unless the court needs a break, or Sergeant Wakeson.
You okay, officer?
I'm doing great.
Let's at least go for another half hour.
Okay,
before we
thanks.
take a break. So go ahead. Okay for another half hour?
Good morning, Sergeant Wakeson. How are you today?
I'm doing good, how are you?
Good. Oh, I'm fine. Hey, during my examination of you, I'm gonna use the term interrogation, and you can use the term interview. Is that okay?
Agree to disagree,
Okay,
that's
because I
fine.
just don't want to get bogged down, on
Sure,
semantics.
that's
I
fine.
think this is an interrogation. You think it was an interview.
I'm fine with that.
Okay. So, and I'm focusing on, let me focus mostly on December 7th. And now, I'm going to give you, this is Defense Exhibit A. This is a copy of.
Thank you, Mr. Howard. All right, appreciate it. Same as the copy in the binder you gave me, Mr. Kalichuk?
It
Should be, but I haven't-
The binder contains,
Other stuff,
number of
including-
interviews like Renfro's and whatnot, but
Okay.
Austin Barrett should be the last one in there.
Yeah, it's number 10. There's a few other things in there.
But this is one, Judge, if you can feel free to mark on or something like that, because I'm going to be focusing a lot on this transcript.
Okay.
So, as of December 7th, we know it's uncontroverted that Austin Barrett was seen with this group of people, correct?
December 2nd, he was,
On December, yeah. We
Correct.
know that.
yes,
And we know that before the homicide, he's been hanging out with these people, right?
yes,
And after the homicide, he's been hanging out with these people.
and during, but
Right.
yes.
And in fact, at the time of the arrest of Almandinger, on December 7th, he's the last person that you're going to interview. You're trying to get an interview, right?
Yes,
Because you have grand jury the next day.
yes.
And the issue is whether, and has a subpoena already been,
I don't recall.
okay. And was he actually going to testify at the grand jury? Was Mr. Kalichak going to call him?
I don't remember.
Okay, was this a whole ruse just to get him down there?
For grand jury?
Yeah, for grand jury.
Oh,
See, I
absolutely
got a
not.
subpoena. Okay. Now, what happens here is on page 1, this starts at 1355, but what happens is, according to pleadings filed by Mr. Kalichak, is that you get an anonymous tip that Austin may be showing up at this food mart,
That's correct.
right? And is this, did you actually hear the tip? Was it like a recorded tip?
No, I don't want to mix up, we got a lot of tips in this, I don't want to
Sure.
mix them up.
No.
And so I want to say that we had an individual call in and say that they wanted to be anonymous, but that they knew that Austin was going to be at the Wasilla Fushhook Food Mart, and we could contact him there.
And was that a male or female? Do we know?
I think it was a female. If I'm not mixing my tips up.
And was this was this person doing it for money? Was there a reward out or anything like that?
There wasn't any reward that AST was offering.
How far is it from, and And where's this food mart located?
Wasilla, Fishhook, and Selden Road intersection.
And do you know what food mart that was? Did you
Yes.
know? Okay.
Yes.
All right. And how many miles is it from AST to there?
7 or 8 miles maybe.
And so the plan is to send some people, Sergeant Ingram and this, is it Decor?
Investigator Decor.
Investigator Decor, to go see if he's gonna show up, right?
Sounds about right.
Right, because we don't know if he's gonna show up or not.
That's always the risk with those tips.
And so what was the plan? What was the plan? Are you the lead investigator? Are you running the show?
It's a team effort, that's correct, but my name's at the bottom of the report.
So what's the plan? If he shows up,
To detain him and bring him back for questioning.
right, and who made that decision?
I'm sure it was a collective decision.
Now, you didn't talk to Mr. Kalachak about that.
I don't remember talking to him, that's correct.
He's your legal advisor.
He's the district attorney, that's
Right,
correct.
I mean, if you have questions of law or anything,
That's sure. Yeah,
you
talk
can
to him
call
or one of
Mr.
his folks.
Kalachak. Let me finish, please. You can call Mr. Kalachak up and say, hey, can we do this? Is it kosher to do it?
Yes,
Yes, and you've done that before.
I believe so, yes.
You have, right? And that's always good because it covers, you don't want to make any mistakes, right?
I would prefer not to, yes.
Sure. And you've made mistakes and
Everyone has.
everyone has. So what happens here is you send them off to, and you know, and in fact, Mr. Kalachak is never told on December 7th, the entire day, he's never told about how the takedown went, the detention went down. He's never told that,
Sure.
right?
Well, not until we get there.
Right. Well, no, he's never told. You never tell him, even when he's interviewing Mr. Barrett, you never tell him that he was taken down in custody.
Sounds like you're making that statement. I don't remember not telling him or telling him.
We'll get to the statement, where Mr. Kalachak asks, is this man in custody? Do we have to worry about him being in custody?
Okay.
And you say, no, he's not in custody. Do you remember saying that?
I don't remember saying that.
It's in black and white.
Oh, then I said it.
Right.
I
So
just don't remember saying it.
what you could have done is, Mr. Kalachak has no clue that this man was detained by handcuff.
Sure,
Right. And you know that you have to have probable cause to do that,
that's correct.
right? And I suppose you could call up Mr. Kalachak and say, Mr. Kalachak, this is the plan, this is what we're gonna do. Do you give us the go-ahead that you think this is probable cause that we can go ahead and do this?
I could have.
Could have, but you did not do that, did you?
I'm not required to, but you're correct.
Right.
I did not do it.
And you took a risk that if there is no probable cause, then there's a problem.
I would agree with that if there's no
You would
probable
agree with
cause.
it. So what happens here is, this call comes in at 1 o'clock. Is this a work day for you?
December 7th, I don't have a calendar.
Is Mr. Kalachak in the office that day?
I think he was, yeah.
Okay. He shows, the interview starts at 1:55.
Yes.
So sometime between 1 o'clock, and I assume no one's, what's the speed limit out here? Is it 25, 30 miles an hour out
It
there?
depends on where you're at, what the speed limit is. On Bogard and Selden, it goes between 50 and 45 miles an hour. On the side roads, it's obviously either 35 or 25. It depends.
So how far do how long do you think it takes them to get, if you get the tip at 1, when do you think they show up roughly?
I don't remember when they showed up.
15 minutes out, 15
Sure.
minutes back?
If they went straight there and contacted him and straight back, it'd be a 10 to 15 minute drive there and a maybe 10 to 15 minute drive back with a couple of minutes in between to make contact with him, let him know what's going on, get him loaded up, that sort of stuff. It's just driving time.
And obviously, do they wear body cameras or not?
No.
But Sergeant Ingram has a recorder going. This whole thing is recorded, right?
Okay. Sure, yeah.
Are guns pulled out or not?
No.
Okay, so what happens here is Austin is in, and they're wearing uniforms, or are they non-uniform?
Plainclothes.
Undercover, huh?
Plain clothes.
Plain clothes. And what happens is, Austin's trying to do some purchase, and I'm using the word a takedown. There's a takedown happens, right?
We make contact with him
Right.
and we detain him,
Right.
yes.
And suppose one option would have been to say to him, hey, Austin, we'd like to talk to you. Do you mind, coming in the car and we'll voluntarily and come to the station?
Sure,
You could have done that.
could have,
That's option A, right?
sure.
And option A would have not had this whole issue of probable cause. If you'd done that,
Arguably,
all right? But you don't do that.
because we had probable cause.
That's what, it's the police determination that you have probable cause, right?
Well, based on the,
Right.
yes.
He has not told you you have probable cause.
Nor has he in numerous other cases I've investigated.
Right. No. And it would have been an easy call to say, hey, do we have PC to do this? Real easy call. Right?
That's a matter of opinion.
What, but this
Mr.
is-
Kalachek's a busy man.
I know he's a busy, this
I'm
is,
busy.
this is one of the most,
I don't know how easy that call would be is my answer to you.
this is one, pick up the phone and dial him.
Okay.
You guys' office are real close.
Let's go with, I could have called him and I did not.
Right. And you chose not to. That was a decision by you.
It was a collective decision, but sure.
So you detain him. The way this goes is he gets put into custody. He's bent over. They put his hands behind his back. And what Austin says, he says to, and this is on page 17 of the state's opposition, which is a judicial admission, that Ingram approached Barrett and stated, Sergeant Ingram, AST, put your hands behind your back. And Austin says, am I being detained? I'm just being detained right now. That's the quote.
Okay.
Okay, so he is being detained,
No argument.
right? No argument. And then the response is that he's going to be retained, and Ingram says, for right now.
I wasn't present, but if that's what it says, then
Yeah,
I'll
this was-
agree with you.
You don't
Sure.
have any doubt. I mean,
No, I don't think
Right.
you're making
So-
stuff up.
so we have a man who's in police custody,
Agreed.
right? He's in custody.
Agreed.
Yes. Because detention is a temporary,
Yeah,
Custody.
for the purposes of this, there's no doubt that he's in handcuffs, with his hands behind his back, and Sergeant Ingram told him he's being detained.
and he's in custody. Right?
I would have to say yes. I think custody and detention are kind of synonymous.
Great. You're right. Detention and custody are exactly, they're synonymous. Right? Correct? So, I mean, I have a Merriam dictionary here. It says, defines detention as a temporary state of custody. You agree with that?
I would have to, yeah.
Right. So, and I think the transport tape is about 20 minutes. 20 minutes, and I think, have you listened to the transport tape?
I have not.
Okay, but if I represent, it was 19 to 20 minutes.
Sounds
You have no
about right.
problem with that? Okay. And now, at this point, you have Erick Almandinger's statement in the can, and you've got Renfro's statement in the can. You're not going to get a statement from Johnson, are you?
No, that's correct. We
All right.
didn't.
So this is your last of the alleged
But don't forget Devin. We have Devin.
You have Devin's in the can. But the
Yep.
people who are allegedly at the scene, this was the last one, right?
And don't forget Alana's. We have that one in the can.
And you know at this point that you have to read Miranda warnings.
Absolutely.
You have to,
He's in
because
a
he's in
police-
custody.
He's in a police station,
Right.
came in handcuffs. He
So
gets
you know you have
Miranda's.
to read Miranda warnings.
That's correct.
And there's always that chance that when you read Miranda warnings, that
Could say no.
he may say no.
Yep.
Right? So you have to try to hedge your bet as to try to get him, do everything you can to get him before that.
It's a
correct?
strategic decision that we
Yeah.
make. Yeah, it's always a roll of the dice, for sure.
You ever hear the Reed School?
Yeah,
Yeah, Reed School of Interrogation. You know something about that?
I know something about that. Yeah.
Yeah, do you use Reed School in this interview?
No,
Techniques?
I've been asked that a couple of times. I don't use their textbook techniques. I think they have some I think they have some pros and they have some cons, but I've developed my own method, if you want to call it. It's not really a method per se, but it's just my way of doing interviews.
So are you saying that you didn't know Reed School?
No, I'm not saying that at all. I'm just saying I didn't use their textbook. Here's how you go through this. There's a checklist of sorts, and you know, I mean, I'm sure you probably very familiar with the Reed technique, and you'll see pieces that resemble the Reed technique in this, and you'll see pieces that are completely contrary to what they would do.
But you would agree, that there are portions in this, the way you approached it, Austin, that there were some portions that they might be recognizable as Reed's,
Sure.
with the Tony Wegson spin to it.
Right? I think that's a pretty accurate statement.
And of course, some employees are omniscience ploy, that, hey, I know everything, I know everything about the case, you might as well just confess because, save yourself because I'm in the know.
Sure.
That's one, right?
That's one.
One is the evidence ploy, that you have incriminating evidence against a person, and that you get them to believe that, evidence is going to crush them, and you better roll over, right?
That is one that could be used, yes.
Minimization, that one? You minimize things?
You didn't really mean to do this, that it's an
Right,
accident.
You're a nice kid.
something.
I can, you just got caught eating a shit sandwich. That's your term, right?
Whatever.
Is that a Tony Wegson spinoff of the Reed?
It may
Shit
be.
sandwich?
It may be.
Yeah.
Sure, I've adopted a long-
Implicit promises.
I don't know what you mean by that.
Well, inducements. Hey, we can help you. You seem like a good kid. All you need is rehab.
Yeah,
Get
you
back into school.
Got to be pretty careful about that
Yeah.
one. I don't like that one at all.
Social pressure.
What about it?
Well, just saying, hey, you got these people are feeling bad because their son is dead. Don't you feel for them? Those kind of things.
Sure.
Go ahead. You used that in this case, didn't you?
I don't remember.
All right.
Maybe.
Well, let's go to page 1.
Okay.
Page 1. He's still handcuffed, and let me see. He's been handcuffed, brought 7 miles, into the belly of the AST, the beast of the belly of the AST, in an interrogation room with his handcuffed behind his back. He's not going anywhere.
I would say yes.
He's not free to go.
Which is why he's read Miranda.
Right. And you ask, can we undo these? And those are the handcuffs,
That's correct.
right? And we go to page 2, and you start out at the beginning. That's a grand jury subpoena you've handed him for tomorrow. We'll talk about here in a minute. Don't worry about it too much.
Sure.
Okay. Now, you see the top of page 2?
Yeah, I'm there. Okay.
Now, has that already been signed by Mr. Kalachak?
Has what?
Hey, the subpoena that you're giving him.
It's a subpoena for grand jury that's happening tomorrow.
Yeah.
I don't know that it has his signature on it, if that's
Okay,
what you're
well,
asking. It's
Now, this next paragraph. You say, now obviously you're down here in the police station. You came down here.
Yeah.
Right? Now, he didn't.
We brought him there.
He came down there, but he didn't come down voluntarily.
Right. We brought him there.
Right. The better word would have been, we brought you down here against your will.
Sure.
But came is kind of like a little more minimization.
That's okay, but that's not my intention here. I'm just trying to talk to the guy.
Right. Well, what you're trying to do is trying to keep it so that a person doesn't start sweating that, boy, I'm looking at some real problems before you read Miranda.
That's not the purpose here.
Okay? Well, the other thing you come on, it says, I'm going to tell you right now, no matter what you tell me here today, you're leaving on your own. In fact, depending on how this goes, I won't mind giving you a ride. Right?
To wherever you need to go after this, right?
It's important when we go through this interview that you understand that that's the result. That's what's going to happen. Do you understand that? So what you've done here, do you know what a condition precedent is?
Maybe, but I've never heard it described as that. What is
Okay,
it?
a condition precedent is kind of a law thing, in the law, especially in contracts, where something has to happen. Something happens, but that doesn't happen until some other predicate fact happens. Do you understand me?
Kinda.
Okay, well, let me explain this to you. I asked my wife to marry me. She said, sure, I'll marry you, but first, you've got to go to Washington, because I want to live in Washington, and you've got to take the Washington State Bar. See? So that's a condition precedent.
Makes sense.
I'm not getting married unless I take the bar exam.
Sure.
So what you do here is you predicate, there's going to be an interview that I'm going to let you go after the interview.
That
Right?
was the plan.
That's a Reed School technique.
If it is, I do not recall that being one.
Well, what you're doing is, he gets to go only after an interview. There has to be an interview.
Well, no, that's not necessarily true.
But that's what you
No
said.
matter what you tell me here today,
Right.
you are leaving on your own. No matter what you tell me here today includes, I don't want to talk to you.
Okay, but does it?
Well,
Okay.
essentially
So
at that
he
point.
can say, if he says to you, I don't want to talk to you,
Then I
you
have
will
to
let him
make
out
a
of jail, you let him go immediately.
I have to make a calculated decision after that happens.
Okay, well, that happened
But-
a few times. Right, so you have who determines when the interview ends? You or him?
I suppose it's a group effort.
Yeah, who has the power here? You or him?
Well, I'm not waterboarding him, so technically he does.
You know, Mr. Kalachak brought up the fact that this Austin had police contacts before, so he must be really savvy to your techniques. Maybe we have to, use different techniques. Is that what I heard?
No.
Okay. So you're not using maybe an enhanced form of,
There is nothing enhanced about anything I did with this.
okay. So you're not using more of a read technique just because to try to get around?
I couldn't tell you today
Okay.
what Reed tells
Well,
you to do or tells you not to do.
Let's go to this. Let's go to the next. You say to him, "Yeah, exactly. However, because you came down here and we gave you a ride. You were just in handcuff, which it is what it is. Because of that, despite the fact that you're leaving afterwards, I'm going to read you your Miranda rights."
Correct. And just to be clear here, something that we haven't talked about that's probably worthy of mentioning is that it's been our experience that when these folks are in front of their friends, that they're less likely to feel comfortable talking with the police, even if they want to talk to the police, because of the perception that they could get from their friends. And so while not directly related to that paragraph, understand though that the tone was that he came out of a car full of his friends, and that yes, we absolutely put handcuffs on him and brought him down here.
Right. And do you know who was in the car? Was Dominic Peterson there?
Dominic Johnson, you
Dominic
mean?
Johnson?
I don't know. Sergeant Ingram probably answer that question better.
But what I'm focusing on here is you start to talk about the events of how he came to be, but you catch yourself. You don't go into the gory details about being handcuffed and and being, takedown. You just.
I don't
stop.
need to. He's present. He's got
Right.
the handcuffs. He knows what the gory details were.
And
I
again-
don't have to explain to him what happened to him. He knows.
Because we gave you a ride, not because you were forcefully brought down. The gave is like you're volunteering it. You're a nice guy. That's a word that you chose.
What paragraph are you referring to?
We gave you a ride.
Oh, okay. I see.
Okay?
I thought
And
you were
then this is
referring
the
to the nice
classic.
guy.
The classic is, it is what it is. It is what it is. It's like something out of Seinfeld. When I use the word, what it is what it is. Have you used that before? Just with talking?
Sure I have.
Sure. When you want to keep things vague, you sometimes say, hey, it is what it is.
Or if it just is.
Or if it just
what
is.
it is.
Or if it's just or if you don't want to talk about it. Well, what is it is. What at this point, it is what it is. What is
It
Austin
is.
Barrett supposed to interpret from that statement?
I have no idea.
Yeah. And what it is this man is now in custody, and you're going to interrogate him on a first-degree murder case. That's what it is.
Which is why I'm going to read you Miranda as the last
Right.
thing that I
But-
tell him before I read him Miranda.
But you don't want to say that to him. You don't want to tell him. If you had told him, you're sitting here in custody, I'm going to interview you as a suspect in a first-degree murder case, that would all be true.
But I'm not required to tell him that.
I know, but you're minimizing it because if you do tell him that, maybe he might invoke Miranda. He just might.
Am I supposed to answer to what might have happened? I don't understand the
Well,
question.
It is what it is. That sounds a lot, it is what it is, doesn't sound as threatening as, hey, I'm going to ready to interrogate you on murder one. Correct?
Sure.
Sure. So then at this point, you know, we always hear about the good cop, bad cop. Ingram is sitting in on this, right?
I believe so, yes.
Right, and he pipes up every so often and is this kind of a free flow? I think you've described the interview as kind of a free flow thing.
Kind of is, yeah.
And then Ingram types up, oh, this is Beachhead. This is the showtime. So this is his chance to talk, and you only get one time to do it. And those are all kind of preparatory to the, and you read the statement. And then one of the statements is, you have the right to remain silent, and one is that you can exercise your right to not answer at any time, right?
Yeah, I read Miranda off a card, so.
Yeah, you read it off a card, and which is a good. You have the little card in your book.
Something along that line.
You've say you've met him a couple of times on the street. Had you met him before?
Well, he was there December 2nd when everybody else was around, but
Right.
December 2nd kind of grew its own set of legs, and he didn't get talked to that day.
And then page 4, you say, hey,
Oh, no, he tells me, I remember first seeing you when we were on the street. That's
Okay.
when he tells.
Okay, right.
I actually, so that we can add some context here, I think he thought I was somebody else at that point, but, because I'd never met him on the street, and I didn't understand what that statement meant, but nonetheless, that was his statement, not mine.
And let me just, if I remember it, start out with this. Austin, you and I sat together, and Austin told you all about the homicide with
Frankie.
Franklin, right? And he actually assisted in wearing a wire, right?
He made a call, he made a phone call from in the interview room to somewhere else.
And
Yeah, no wire involved, though.
or you know what? Yeah, well, it's I don't know the technology.
Well, you were there.
But he actually, the government actually used him to procure an indictment.
I'm sorry, ask that question
The
again?
government used him at grand jury to procure an indictment
Against Damian Peterson.
against
for
Damian Peterson,
murder
who
of
is the
Frankie.
brother of
Davin
Davin Peterson,
Peterson.
right?
All
And-
correct.
And Damian Peterson, he cut a deal with the government. He was charged with murder too, and he pled to murder, manslaughter, and was given, what, 9, 10, 11 years?
I don't remember.
Okay. But I assume the state would not put someone who's not trustworthy before the grand jury to indict somebody to then put him in jail.
Well, that we would try not to, but we're dealt the hand
Yeah.
we get, and
Right.
sometimes there's 3 people in a room and one of them dies, and 2 of them are not great people.
But someone made a decision that he was trustworthy enough to put before a grand jury.
Yeah, a judge, after reviewing our warrant, to do so.
Well, the great, whoever, I don't know if it was Mr. Kalinchik's case, but the DA found him trustworthy enough on that homicide to use him.
To make
try to make a
monitored,
case.
recorded statements against Damian Peterson
Right.
for the purpose of securing
And he
statements from Damian about Frankie's death.
Right. But
Yes.
he testified at the grand jury is what I'm saying.
Sure, yeah.
Yeah. Okay. So then you go on, he's talking on page 4, you're saying how you and Ingram have 30 years of law experience and that you guys know what you're doing. And that you thought
All
you were,
correct.
if right down first paragraph,
Yep.
if you thought we thought you were Osama bin Laden, you wouldn't be here in cuffs, you know.
Yep,
You know,
I've used
I
that
wouldn't be
before.
promising. That's all kind of minimization stuff, right?
Yeah, I think you could classify it as that, yeah, sure.
Yeah.
I don't think he's Osama bin Laden, yeah.
And then he says, on page 5, is his first denial, right there. He says, I wasn't there when it happened. Just like every other one of those interviews, he denies it, right?
Yes.
Right? And then right there, you stop him and say, stop right there. Like I told you, I know I'm not going to be guessing. And you give him a little lecture about telling the truth.
A little bit.
Okay.
Yeah.
And then we talk about the grand jury in bottom of page 5.
Okay.
Page 6, bottom of page 6, you're telling them this is your chance to, tell us about everything, and then Sergeant Ingram cuts in on page 7. You're going about, all the physical evidence. We got electronic stuff. You got DNA. you got all this evidence, and we've got it almost solved, but we would like your help. Is that kind of a minimum? Is it kind of telling them how much evidence you got in evidence employee?
I think both of us, Sergeant Ingram and I, both handle our interviews very similarly in that we're being upfront. Like, it's not looking good, and we'd love for your side of the story.
Sure.
And so, yeah, we sometimes tilt our hands a little bit. We don't not going to show every card we have to protect the integrity of the investigation and ensure that the statements that he gives us, we aren't actually giving him and he's agreeing to. It's that it's willingly coming from him. So yeah, in those cases, we do end up talking about some of the evidence we have, or the statements that have been made, or the factors that had brought us to where we're at.
So the bottom of page 8, you go on to this notion of, Ingram's talking about, we've all grown up, had friends that were like, probably wasn't the best to have, but that's the situation.
Sure.
Both of us have been in the hot seat multiple times, and as accusations made against us. When we got hired, we had to spell it out. We had to say all the bad stuff we did as kids, no one died from the stuff we did, but we did some pretty bad shit.
Sir.
And that's all minimization to try to get a relationship with him that, hey, everyone does bad stuff, right?
I don't know that I'd call that minimization.
But it's a technique. It's a read technique.
It's a rapport building, if anything.
No, it's a what?
Rapport building, if anything.
Okay, rapport building. Okay. And,
If anything.
Because you want to try to get this kid to
Like,
open
hey, you're human. We're all human. Bad stuff happens to
up.
humans.
And then you have your standard line here. You must say this to everybody. Mistakes don't define you unless you let them, I guess. Mistakes shouldn't define you. It's what you do after a mistake, et cetera, et cetera. Was this a mistake? Sure. Was it a big one? Absolutely. But, it's what you do afterwards that defines you as a person.
I think
That you can go on for the rest of your life. That's all minimization stuff.
No, that's accurate. That's just a fact of life.
Okay.
People make mistakes. The mistake doesn't necessarily define you. What you do after you've known you made a mistake more accurately defines you. That's
Right, and what you're telling them is that if you admit your mistake, you won't have a decent life unless you miss your mistake.
That is definitely not what I'm trying to. I'm not going to tell him he's going to have a decent life at any given time.
What?
I tell him that's what's important, and the path it could define the path you take for the rest of your
Right.
life, but whether it's going to be a good life or a bad life,
And
I don't
then
know that that's an
You
act.
go on about how important cooperation is,
Sure.
right? And
That is taken into consideration.
Right.
That is it. That's
then on page you use the word when it sounds good when you're sitting in the pack, but it just becomes a different story when the metal hits the meat. I've never heard that before in the police station. You know what I mean? And he said, then we get this discussion, metal hits the meat like handcuffs, right?
That's what he says.
I mean,
Metal
so
hits the meat like
what's
handcuffs.
What's that whole thing?
I don't know, so-
What are you telling him when you say it's a different thing when the metal hits the meat?
What I'm telling him is everybody talks, and that you might be with your buddies around the campfire or wherever, talking about how I'm never going to say anything to the police, but when push comes to shove, or the metal hits the meat, which is a term I've used, it's just something I picked up in my 40 years of being alive, it is a different story when you're in the police station talking about the case than it is when you're around the campfire with your buddies talking about how tough you are. That's how I prefaced that statement was everybody talks. Everybody does.
Everybody talks. So
So the metal hits the meat like handcuffs or something is his question. And I follow up with, it's just a figure of speech.
the page 11, you tell them this is why we brought you here, because we want to hear your side of the story, right?
I do say that, well, Sergeant Ingram actually says that, not me, but yeah, it's said.
And then further down, Sergeant Ingram apologizes for the seizure. I'm sorry it was so abrupt the way we had to do it,
Sure.
right?
Yep.
Now, at this point, do you tell him at this point that he's free to go?
Well, we've told him before, but not right at this point, no.
No, you've never told him. At this point, you have not told him he's free to go. He can just walk out the door.
Well, no, okay, I guess the inference would be that no matter what he tells me, he's leaving. I suppose one could infer from that, but you're right. He doesn't
At
get
this
told.
juncture, at
This
this
juncture.
juncture, he cannot leave that room.
Which is why he had Miranda read to him.
I know. He gets at page 197, we'll get to that, when do you think the detention ends? When do you think the detention ends between page 1 and page 230?
I haven't read through every single word of this, but I think the detention in this case ended when we asked him where would he like to go after this.
Okay. That would be at the end of this all,
I agree.
right? So he's in custody. He cannot leave during this entire interview, correct?
I'm gonna have to agree with you.
Right.
Let's stop there,
Thank
Hey,
and we'll,
Judge, I just wanted to bring something up. I don't know if I want to, just commenting on the elephant in the room. I know, Mr. Howard is going, all these things that I have to do with this motion that's on the table right now. It sounds to me like Mr. Howard is gonna be writing a brief on voluntariness, while Mr. Provost, Your Honor, and I will be trying the Renfro case in Fairbanks. I mean, the notion, like I was just thinking to myself, if the appellate court reviewing this case and sees a defense attorney raising a new issue 2 days or a day before the parties are going to pack and go to a distant venue for a jury trial, I think everybody's eyebrows would be raised. And I just wanted to raise this earlier than later. I think I'm commenting on what everybody in the room is already thinking about, that this is a motion that could have been filed years ago. We don't even have this stuff on paper yet, even though Mr. Howard hinted at it. I'm okay in the interest of efficiency, and I feel like I don't think the officers even need to have a clue as far as seeing his new pleading or whatnot, because their answers are gonna be their answers regardless of whether they see his motion or not. But just looking at the big picture, I am seeing the case of State versus Bradley Renfro being tried in Fairbanks, while Mr. Howard is writing a huge brief on voluntariness, and then eventually the state's going to have to respond to that huge brief, because as the court probably knows, you can write a book on confessions and voluntariness and case law and whatnot. And I personally am not convinced that we can handle this in just like an ad hoc manner, a day before or 2 days before we start a jury trial.
well, Mr. Howard, let's get your response to that. Is that
Well,
your
Judge,
intent at this time?
The intent, and I explained this,
I
guess I told you telephonically, and I didn't have a lot of time to talk about it. I don't know, my idea is to, because I let him go through this, we got into the statement. He got to talk about how, was he pressured and all that.
Well, Judge, I did that because the court, last time Mr. Howard said he was gonna raise this and explore it.
And the
So, I mean,
court,
it's not like-
really wanted to hear some of the underlying facts of what occurred in the statement. His statement was never played in the first 2 trials, has never really been an issue.
What I'm
So-
saying, Judge, is that I told the court, and I can go through my spiel now why I'm going to need a continuance. And
Well, I think that's the question.
Well,
Do you
yeah.
intend on
That's-
filing
No,
a
I will
motion?
be.
Judge, we're on the brink of loading up trucks and
Yeah,
boxes
I know.
and clothes to go to Fairbanks, and we got a new motion here at the last second. This is just not the way things should be in murder case.
It isn't, I agree with that, but what we should do, because what I assumed was going from last week when we represented, I said I could make this evidentiary hearing could be used for both the probable cause and for the motion.
You
I
stated-
did say that, and so I tried to expedite things, and so that's what I was gonna do. Then I was gonna ask for once you saw what went on in the substance of the motion, then you're gonna say, then I'm just gonna make my motion to continue or to sever out myself for all these good reasons. And then when you see what went on and how Mr. Kalachak doesn't even know what's going on, he was never told this, what went on. Then if you denied the motion to continue, which I think you're gonna have to grant, because it's a constitutional issue, then I was gonna ask you to rule on the motion for involuntariness, and we'll just deal with that. But I need this time to go through this, then we can just argue the probable cause. But if he wants to say right now, we want to cut to the chase, and we want to say, hey, I come back, I explain to you why I need this continuance, and why you're going to have to, believe you're going to have to give it to me, then that will expedite matters, because we should find that out sooner than later.
Well, I think what I'm saying is, Judge, we should have been straightforward about this. Yes, Mr. Howard hinted he might go into other issues. He's still thinking about motions 3 years into the case. And you know, I heard that, and I'm sure when we all heard that, we're going, well, how is this going to affect the trial? But in my mind, we shouldn't do business like this. I mean, the court should not be deciding whether to suppress a murder defendant's statement 2 days before the trial without any briefing by the parties, just by us throwing out legal concepts and cases here and there. So
The difficulty for the court, as you probably imagine, Mr. Kalachek, is that the ball's been rolling for this trial for quite a while. We know that under the state constitution, federal constitution, a defendant never waives his right to a constitutional issue. It can be filed during the trial. It happens. So then I am kind of stuck in a situation to evaluate how this is going to proceed. And that's what I kind of wanted to see what happened today. I've been thinking about the situation that you have already put into play. That if it does come down to a substantial motion that cannot be ruled on before trial legitimately, that I would probably proceed with just the one defendant.
Right.
I have been thinking about that.
And Judge, it would be.
And I have a couple of other questions. I mean, if it does come down to a voluntariness issue as to the statements by Mr. Barrett, I take it then there will be amended motion to dismiss the indictment also. Is that correct,
That's
Mr. Howard? Which ends up being that I can't even start the trial because then there's a motion to dismiss the indictment instead of would you go forward without the statement. I mean, that's something I don't know, you know.
I mean, the court can see the prosecutor's frustration nowadays when
Oh, I
no
can.
motion deadlines ever imposed on defense attorneys.
Well,
I
sadly,
mean, this is the prime example of you can file anything you want, even up to the morning of trial, even during the trial, and we'll make the
and you know that's the law. You know that.
Well, not necessarily.
Well, but with a
Not when a
constitutional
case
issue, I don't think.
I know, but Judge, not when a case has been going on for years. I can understand in a case where somebody had a case for a few months, you know, they come up with
Well.
still thinking about what the strategy should be, but we've done 2 trials where the defense attorneys have been privy to every single iota of our evidence through YouTube, through the transcripts, through the court tapes, so to me, you know, identifying issues, that's what
Okay,
lawyers do.
but
But that said, Judge, I am, you know, it's kind of a choice, you know, I could take 2 routes as a prosecutor. I could complain of the late motion, say, Judge, let's ramrod this through, let's go up there, I'll have somebody from my office have Mr. Howard do his briefing this weekend, I'll have somebody from my office do the briefing while we're picking a jury. But I'm not convinced personally that is how justice should be accomplished in this case in that kind of manner. So, given the choice and knowing that everything gets looked under a microscope by the appellate court and by all these attorneys we pay to do PCRs in the future.
that's
I
the
think
other issue
my
is a
choice,
PCR. So
I'm just being honest with the court. My choice, hearing what I've heard this morning, would be let's go on the Renfro case. Everything's in motion. Mr. Provost is on the phone. He's ready. And then if Mr. Howard thinks as an attorney that this is truly an important issue, you know, I think what he should do is do a motion, do a brief, and the court should give us ample amount of time to respond because, as I said, this is the kind of thing that's been, the confession issues have been highly litigated and there's a tremendous amount of case law on confession issues. So those are my thoughts, Judge. I know this is not, we're not at the point where we're making the final. I just want to let the court know, for purposes of the rest of the day today, I understand he raised the issue of voluntariness. That's why I raised some of the questions with Sergeant Wicks, and I'm willing to spend the day today getting this part of it done, and perhaps this is, I think, a fine way of doing it instead of having the motion written ahead of time. I think we all know what the defense is focusing on, and we can get the testimony done today, but I think later today.
As far as the
The court has
briefing
to make
goes.
some serious decisions as to, are we just going on Renfro, or are we going on both and doing some kind of accelerated briefing schedule? Because I think those are the two options.
Judge, I need a continuance on that, and I told you, that I wanted to see what went on, but
But Mr. Howard, back in March, I still don't understand why this motion could have been filed a long time ago. There's no justification for it.
yes, there is. There
What-
absolutely is. I'm
what is-
starting to get annoyed with Mr. Kalinchak. He and I have been working along pretty well. Let me just tell you what happened in my life, okay? I've done like 394 trials. You know, I'm not really a wilting, liar.
And I
or
don't think
whatever.
anybody's
So-
saying that.
Right, no, and I take everything goes, and what happened in this case is I work at ACC. When this case came in, I've done over 100 involved in over 100 homicides, clearly. Not all of them went to trial, but what happened in this case is when this case came in January 2017, I had 9 murders throughout the state. Because of my experience level, there's 3 other people in my office. That time, no one had tried a murder case. Emily Cooper had tried 1 murder case after this case. So I don't need the high-profile cases. I've done all the high-profile cases. But I had to take this because I couldn't give it to somebody else. So besides that, I had 8 sex assault ones and kidnappings, which are 99-year maximums, pretty much. So I had 17, 18 cases, every one maximum life in prison. Okay, so I have a mother who is dying at 95 years old. I spent 2 years, thousands of dollars, going back every other weekend practically to be her nurse, because she'd had a stroke when she was 78. She was in a wheelchair, totally paralyzed on one left side, but regained her. But she's living in a house by herself because everyone else has died. And my brother had basically living on a small pension. So I spent, if I had been in 2018, the first 6 months of 2018, if I had been in private practice, I would have suspended my practice because I was in no shape to do anything. But I can't do that. I could have filed notices with, my wife can't help me out. I'm trying to keep my family normal, but my mother was failing, and so there's no one else to do it. So I'm her nurse, I'm cleaning her house, I'm doing all of this. So, and my mother died in July last year. And, I deal with death. I deal with death every day. I look at autopsy photos, they don't even faze me. I understand, trust me, Judge, as an officer of the court, I understand the pain the Grunwalds have going through here. I'm trying to expedite matters. I mean, I understand death. If you go to page, see, Mr. Kalinchak gets involved in this because the way they're questioning him is that he can't. They're over 100 pages and they still can't get a confession out of him, and so they suggest that he talk to the PD, the DA, which is kind of extraordinary. You don't really see DAs involved in what happens is page 117. Now, let me preface this. I've never met Mr. Kalinchak before. I find him to be totally a great guy.
Are we in an argument?
No, yeah, we're in argument right now.
Okay.
Right now,
No,
why?
this is
why-
for the motion for continuance.
I would like to compartmentalize it a little bit, Judge. Number one, I was pretty careful not to do any personal attacks on Mr. Howard. Your Honor worked as a state attorney for many years. I have, Mr. Howard has. We know that compared to the civil sector, the number of cases we have, civil attorneys would be shocked to see what we have to deal with and how we prepare cases and how we have to go from trial to trial. I understand all of that. And the court understands the prosecutor's frustration from having to deal with motions right before the trial. In Sergeant Wegson's words, it is what it is. We all understand that. and it wasn't meant as a personal attack. I'm simply trying to figure out, as a lawyer, what am I doing on Saturday?
Okay,
And I'm
let's
trying to-
just get to the crux of it, okay?
117, but look at 117, Judge. 117, Mr. Kalachak, who's very, very competent. I'm trying to praise him. I wish all my prosecutors were like him. And Mr. Kalachak says, well, are we going to, he's not in custody, so we don't have to worry about anything like that. And Ingram and Wigson both say, no, he's not in custody.
Yeah, well,
You
and
see, and the
I
reason
can
is,
tell the court where that was coming from. I didn't know whether Miranda was read to him at the station or not. This was happening pretty quickly. That's what prompted that inquiry by me. So it was.
So I guess his argument's gonna be, how did that impact Mr. Barrett in his
no,
decision
I mean,
thinking?
he keeps saying throughout the interview, I want to go home, I'm invoking my fifth, I don't want to talk to you, I want to go home, and unless they grant immunity to one of the other co-defendants of trying to establish where Mr. Barrett is in this case. So this just happened. I mean, I literally, and that's why this Exhibit A, and I'm not trying to make threats or anything, but when the Court of Appeals sees Exhibit A and they're gonna say, what the hell was going on in that guy's mind, most of those people are former PDs. They're all former PDs, so they know me. So, that's what I wanna do. I just wanna get right to argue the PC. We can have a status hearing. I can do it telephonically.
Well, I still have another witness here for the PC.
Whatever, if you wanna go, that's fine.
Right.
Then,
We've already delved a little bit into the voluntariness. But again, Judge, I know Mr. Provost is on the phone. I'm assuming he's good to go.
And I guess one question I did have for you, Mr. Kalachak, regarding the interview with Mr. Renfro. I take it you were gonna redact everything that had to deal with Mr. Barrett at the trial, and now you are not gonna, if they do grant the severance, that's not gonna be an issue,
Actually,
right?
No, I wasn't, because there wasn't any motion.
'Cause I haven't really even heard the interview with Mr. Renfro, so that was really my question, so.
Well, they give similar, so the way I look at it, Judge, in terms of joint trials, it could be advantageous to defense attorneys. They can kind of team up on the DA. It could be kind of disadvantageous if one defense attorney makes a blunder. It could affect the other defendant's case. I mean, there's benefits and detriments for defense attorneys to try cases together. We all know that. And the statements, we all know from looking at the statements, Renfro and Barrett made substantially similar statements. But because people have lied throughout, you can always pick apart little differences here and there. And I'm sure the jury would see some of that people are lying, people are changing things here and there.
But he does place Renfro at the scene or with the group, Mr. Renfro places Mr. Barrett
Yeah,
there.
but they're consistent on that. They both place each other there. So my main concern, Judge, is just that, again, given what counsel has put on the record, any PCR issues, like, should he have more time? And the other side of the coin is, again, I understand, and I supervise the largest law firm in Matsu, and I do cases, so I understand. But also, like, there should come a point, like, if an OPA contractor has got too much work, that should go up to the commissioner, the director of OPA, and say, hey, I truly have too much work, because I'm hearing Mr. Howard saying, I'm gonna, he's got more years in the law than I do, and he's saying, like, his caseload is such that it's not really doable. I think there does come a point in time where somebody's got to go to the top and say, enough is enough. I can do X number of murder cases, but you're killing me here. Just putting it out there, like, in terms of us setting future dates, I don't know, maybe the court should call in the director of OPA and say, hey, your attorneys are telling me that they have too much work and they can't put the work towards the cases in time for the trial.
I think we've tried that in the past, so it hasn't been successful.
But anyway, Judge, I'm not asking the court, I just wanted to have a little bit of direction. We're going the rest of the day.
Let's take a recess, come back and hear your last witness on the probable cause.
Okay.
thank you.
Okay? This would be,
Sergeant Mike.
Sergeant.
Oh, Lieutenant Mike, I'm sorry.
all right.
Sergeant back then, Lieutenant now.
Okay, can you guys hear us? Mr. Provost?
Yes, Your Honor, I can hear you.
Okay, Mr. Barrett?
Yes.
Okay.
Raise your hand. Do you swear or affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth?
I do.
You can have a seat.
Thank you.
Could you please state and spell your first and last name for the record?
Sure, it's Mike, M-I-K-E, Ingram, I-N-G-R-A-M,
Your occupation?
Alaska State Trooper.
Thank you.
All right, go ahead, Mr.
Thank you.
Dominic.
Good morning. First of all, just tell me what your position is with the state troopers at this point.
Deputy Commander of the Alaska Bureau of Investigation at this time.
And you're a lieutenant now?
Yes,
your
sir.
rank? Okay. I'm gonna turn your attention to 2016, the fall of 2016, late fall of 2016. Were you helping out in the investigation of the murder of David Grunwald?
Yes, I was.
All right. What type of assistance were you providing generally?
So at the time, I was in the Special Crimes Investigation Unit where, our focus was human trafficking type cases and assisting with homicides with special circumstances or that we felt like were more involved or more difficult than your, heat of the passion type of murders.
Okay. And were there other people in your unit that you worked with?
Yes, sir, that's correct.
And
So
who-
it was Investigator Decor and now Sergeant Ramin Dunford.
And was Ballesteros part of your group too? or-
Ballesteros is with the Matsu Narcotics Unit. I was not the supervisor of that unit, but we work closely together.
All right, and in terms of your group, Dave DeCur, Ramin Dunford, were you guys mostly plainclothes when you
Yes,
did your investigations?
correct.
And was it just crimes against people or drug cases too, or was it a variety of things?
We did a variety. It was all felony level type investigations, but
And was this South Central or other places too? Were you called out to other places?
where our unit worked,
Right.
we worked all over the state.
And then who specifically, was it Sergeant Wegson, or did it ask for your assistance in this case, or did it come from higher up in the chain?
No, there's not a real formal, line where someone's asking for assistance, although it can happen that way. Sergeant Wagson and I have a deep working relationship together. It's been known that we share a brain to a large degree. What I mean by that is we're on the same page a lot. We stay in constant contact, both on a professional basis and on a friendly basis. So we're in constant contact. In this particular instance, Sergeant Wagson was put in a new position over at the supervisor of the General Investigation Unit. I was currently in the Special Crimes Unit, and at the time, the way ABI was structured, Palmer General Investigation Unit fell under the command of ABI. So we were kind of already in the know with the Grunwald investigation, or at least the way that it kicked off. And Tony and I started, or excuse me, Sergeant Wagner and I started talking earlier on as the information was coming in and things were developing.
And so would you have been involved shortly after the Bronco was discovered, burned? Pretty early in the investigation, you became involved?
I was involved pretty early, and specifically, I was asked. In fact, I don't remember the exact day, but I know the event of what really got me involved is after Sergeant Wagson had spoke with Erick Almandinger and asked me to do an interview for a person who Erick Almandinger had said that he had gone to a party to in Anchorage. And so that's when I specifically got directly involved as far as doing anything directly involved with the investigation itself.
And as a result of that, it was determined that his alibi was not an alibi really, right?
That's correct.
Okay. And then in terms of contact with the suspects, and well, I should back up a little bit, was the general theory as far as the mindset of the investigators, the more qualified people on this case, the better?
Yes.
Okay.
Yes.
And we know that during part of the investigation, David Grunwald's body still was not located, correct?
That's correct.
So is it fair to say that was one of the things that was foremost on the mind of the group of investigators to do their best to locate the body of David Grunwald, or locate David, if it turned out that he was alive?
Yes, sir, that's correct.
And then, information sharing, would you reiterate Sergeant Wegson's testimony that there were frequent briefings as far as progress of the investigation?
Maybe not formal briefings, but like I said, we were constantly in contact with each other. I would say we were abreast multiple times during the day, daily, throughout the investigation as to what new developments had occurred.
I mean, and what the purpose of that is so people aren't recreating the wheel or stepping on each other or redoing efforts of others?
Yes.
Anything else you can think of?
Recreating the wheel, duplicating efforts. Only one guy can only be at one place at another time, at one particular time. So we may need us to go over and do another aspect of the investigation. And at least we know the reasons why that we're doing that. So that was the reason for the constant communication.
All right. And I know you weren't involved in every interview, but you did participate in the search warrant at the K Lake Road Peterson residence, correct?
That's correct.
All right. And I believe in the prior trials you testified about the seizure of the 2 firearms, correct?
I think there was actually 3.
3, including the revolver, right?
Right.
Right. And then there was some materials associated with Austin Barrett at Devin Peterson's house also,
Yes.
close in proximity to the firearms?
I remember distinctly, there was a knit cap that had a Ouija board design on, it was inside the backpack where the guns were located.
Okay. And you recognize that as being a hat that he had wore previously?
Yes, only I learned that from a photo that was obtained through a social media account that we had gotten through via the warrant process, or I remember specifically seeing a photo. I'm pretty sure it came from a social media account, possibly Snapchat. I don't know from whose account, but I remember Austin Barrett wearing that particular hat.
And I know the way these cases unfold, sometimes the things we consider important later are not viewed as important during the time they're found. But do you also recall seeing Austin Barrett, a wallet with Austin Barrett's identification at the location too, because it appears in some of the photographs?
Yeah, I remember seeing the photo and of that. I know what you're talking about. I don't have a distinct memory as to where that wallet came from, but I do know that the house was small, where we did the search warrant. In fact, the backpack, as soon as you come through the door in this small house, you got a mattress laying on the ground as you're coming through the door on your left-hand side. The backpack was sitting right there. And then, a table, and then kitchen. No walls really dividing any of that except for a back bedroom, which I believe belonged to Philip Seal and Alana Peterson at the time.
Okay.
So I can't say specifically where the wallet came from, but I do have a distinct memory about the hat.
Right, and we both can agree that, his wallet being there, his ID being there, doesn't make or break the case as far as, the being definitive evidence against him in this case, correct?
I would have, yes.
All right.
Yeah.
Now, as far as your more direct personal knowledge, you interviewed Alana Peterson, right?
Yes.
And the guy that lived with Alana Peterson?
Philip Seal.
Mr. Seal, yeah. And did Ms. Peterson provide you some information about Austin Barrett and him coming to the house or being dropped off at the house?
Yes.
What date?
November 13th, 2016, the night of the murder?
You were asking me what time did I interview her, or
No.
what time?
Well, I could ask you, did you interview her the same day as the search warrant execution?
Yes.
All right. And during the interview, did she tell you in her own words that Austin Barrett was dropped off at her house on the evening of November 13th, 2016?
Well, I don't remember if she said the date, but she said the night the Bronco came over with the rest of those boys.
All right, fair enough. And did she say that she personally saw Austin at her place?
Yes.
Did she describe some of his behavior also?
Yes.
And what do you remember her describing as far as his behavior?
I don't recall verbatim, but I know essentially that she recalled Austin acting skittish around the house. Anytime there was vehicle traffic going by the front of the house, he would go check the window as if he was scared or nervous about something. There was a dark-colored Dodge Neon. She mentioned that she also recalled him staying the night in the Dodge Neon. that was also on the property.
And would
And
you
it was
agree
pulled
with
out.
Sergeant Wegson that by the time that you went to contact Austin Barrett, the group of participants in this event were pretty well defined at that point?
Yes,
I mean, were you aware that Erick Almandinger had implicated himself in the incident by putting himself at the scene of the camper and the scene of the murder?
yes, sir.
And likewise, were you aware that on November 30th at WPD, Bradley Renfro eventually placed himself at the scene of the camper and the scene of the murder and
Yes.
in the Bronco? Okay. And then just to take it further, were you aware that, you know, the research into the phones and into the taxi records showed that Dominic Johnson's phone was used to contact the taxi company to get him from the
Yes.
Little Sioux Bridge? And you obviously were also aware of the bigger event on December 2nd that Dominic Johnson agreed to take Sergeant Wegson to the general area where David Grunwald's body was found, correct?
Yes, and in fact, I wasn't even in state at that time. I had left, but I was still in constant contact with Sergeant Wegson and the rest of the guys, and was getting up-to-date intervals as to what occurred that day.
And were you aware that, maybe you have some personal knowledge about this, but were you aware that during the course of the investigation, the suspects continued to associate?
Yes,
Like, for example, I don't know, were you at Almandinger's house when Almandinger was arrested and Austin Barrett was there on the premises?
no, but I was told about that.
All right. Or were you there, were you one of the investigators that saw the goings-on in the Valley Hotel in downtown Palmer on the morning of the 2nd or not?
No, but I was told about that too.
All right, so you're aware of those things. And as far as bigger picture stuff, were you aware that Erick Almandinger kind of named one person first as the shooter, then changed his mind, named Johnson first, but then changed his mind and named Barrett later in the interview?
Yes, I was aware.
And were you aware that Renfro blamed Erick Almandinger for the shooting?
Yes,
And you were aware that the agreement was made with Johnson that he not say anything, but just to help find the body?
yes,
right?
yes.
Okay. All right. Now, is there anything else, let me ask you, just an open-ended question. Was there anything else about Austin Barrett that you knew before December 7th, that when you made contact with him or not?
So, collectively speaking, not directly related to Austin, but I was aware that there was since I ran a human trafficking unit, we were suspecting that this gal who I don't know, it was a back page or something along those lines, had put up an ad and had lured a particular John, she was a young gal, to a house. We thought that maybe there was some human trafficking involved, and I do know that Austin was with the crowd that was either interviewed or investigated regarding that particular incident when the John showed up and he got beat. And I don't recall who specifically investigated that, but I do recall Austin's name at least appearing in that particular investigation.
And there was a plea in that case, right?
Sir, that's a great
know?
question. No, sir, I don't know the outcome.
I believe it was reduced to misdemeanor.
I don't think Austin was charged in that case. It was, that was the one where Damian Peterson got his first felony conviction.
The kid was the other person was from Eagle River.
Right.
Okay.
Right.
And then I noticed in the interview, you kind of brought up the photo with Austin Barrett with the watch with the Rams. I think the transcript says Lions heads, but I think they were Rams heads. And you had an inkling that was probably stolen property from a burglary, is that what it was?
Yes, sir.
Okay. So you, at the very least, you knew that Austin Barrett was likely involved in some criminal activities before you contacted him. I'm talking aside from his involvement, in the beating and in the murder. You had an idea that he was involved in criminal activities generally, right?
Yes.
Okay. And as it pertains to what your purpose was on the 7th, you set out to pick Austin Barrett up, right?
Correct.
Okay. And I assume there was some discussion before that between you and Investigator DeKirk, because he was with you, right?
Yes.
And was Sergeant Wagson involved in that too?
Yes.
Okay. It was, what, you were informed that he would be at a certain place at a certain time, or likely be at a certain place at a certain time?
We had gotten some information that he should be at a particular location at a certain time. That's correct.
And it was gonna be you and it was you and Investigator DeKirk that went out there?
Correct.
And ahead of time, did you know what you were gonna do when you contacted him or not?
Well, yes and no. I mean, we play out scenarios in our head. If he was alone, that was gonna be different. If he was with other folks, that was gonna be different.
Okay.
So it really depended upon what scenario got presented.
Now, in terms of, probable cause determination, how many years have you been a trooper?
18 and a half?
And has Sergeant Wegson been a trooper longer than you or shorter than you, or about the same time?
Just probably a year and a half less than myself.
And have you made arrests based upon probable cause in the past?
Yes,
Would it fair to say numerous arrests?
I would say all my arrests.
And in what percentage of the cases do you figure that you had to call a prosecutor to get advice as to whether there was probable cause or not?
Working on the state end, less than a handful of times that I could ever think of. On the federal side of the house, yeah, they're more structured, working with the U.S. Attorney's Office, so I would say more so, but on the state end, it's less than a handful of times.
But in terms of the probable cause to arrest, I mean, prosecutors don't have arrest powers. We have charging powers. We can maybe ask or direct the police officer. We don't have arrest power. Prosecutors don't have arrest powers. So probable cause is really an officer's determination, right?
Yes.
On a daily basis,
I'm not necessarily asking, in fact, even when I confer, I'm not asking for permission to make the arrest. Just looking for any legality issues I may run into. So help us, I guess, step our way through situations that we may not feel comfortable with and be like, yeah, you'd be all right there, or maybe not all right there. And again, I'm being very general
Yeah.
in this analysis, so to speak. But I don't think I've ever called to ask permission to arrest.
Okay. And in this case, it sounds to me, and correct me if I'm wrong, that all of you were fairly confident there was no probable cause. If you needed to get in a situation where you had to arrest him, there was no probable cause in existence at the time to arrest him as an aider and abetter in the murder.
I would say definitely,
Okay.
yes.
And is that one of the reasons why you didn't feel like it was necessary to call somebody from the DA's office?
Yes.
And was the probable cause based on all the various information that we discussed during the course of this hearing, both with you and Sergeant Wegson?
Yes.
And then, when you went out there, again, I know you said you're usually in plain clothes meaning like casual attire usually, as
Yeah.
opposed to suit and tie and.
Casual,
Okay.
yeah, casual attire. I mean, we're not showing our gun or handcuffs. I mean, we're trying to be as low key as we possibly can.
And a vehicle that does not readily identified as a police vehicle,
That's correct.
right? Okay. And tell us how you made contact with Mr. Barrett on the 7th?
He showed up at the Wasilla-Fishhook Food Mart at Selden and Wasilla-Fishhook Road. He showed up in a vehicle with some other individuals. If I remember correctly, I want to say that Dominic Johnson was also in the vehicle. There were a couple others that I can't readily either remember or identify. So our scenario of him showing up alone was out the window. So he was with some other individuals who we knew was involved with this particular investigation. So we made contact with him quickly in the store as he was purchasing some items. I told him to place his hands behind his back. Yeah, he asked me. I had identification. I had my shield and credentials with me. He did so as I instructed, And he asked me if he was under arrest. I said, "You're being detained at this time."
So we can all agree that this was detention for purposes of any further legal analysis, right?
Yes,
Now, technically, you did not arrest him for the assault or beating of David Grunwald at that point,
that's
right?
correct.
Okay, because you weren't asked to do that, nor did you do that, right?
No,
Okay. And did there have to be any physical force used, like did he resist, or, I know he asked, am I being detained? He said for now. But other than, did he resist at all? Did you have to use any physical force? Did Dave DeCur have to help you put him in the car or anything like that?
no, he wasn't he wasn't resisting to any degree.
Now, you heard Mr. Howard ask some questions of Sergeant Weggs, and like, I suppose you could have called him. I don't know if you guys had a reliable number for him. You could have called him and said, can you come down to the trooper
Yeah,
post,
we
right?
didn't
And-
have a number, a house, a particular location. They couch surf. We were lucky to get a tip as to where to find Mr. Barrett. So, and the fact that he was with another known accomplice to this homicide, I felt like we were completely justified in doing what we did and bringing him to a place where we could actually have a good conversation with him.
And in terms of the necessity to handcuff him, he was a suspect in a murder case at this time, correct?
Yes, sir.
And you knew that he had been likely involved in other criminal activity, right?
Yes.
So in terms of officer safety, are you gonna transport a murder suspect to the post without making sure that he cannot gain access to something, or?
No.
Alright, so was this standard procedure in your mind when you put handcuffs on him to transport him?
Well, to be fair, excuse me, can I get some water?
Yeah.
To be fair, I haven't really transported a whole lot of murder suspects. Most of my suspects were, dope traffickers or users or, involved in the sex trafficking type of deal. I haven't really transported too many murderers. And if I did, there was possibly a warrant for their arrest, and they were definitely handcuffed and probably cuffed at the legs too.
Okay. But is it fair to say that if a person is handcuffed, that adds a measure of security for the officers involved?
Yes,
But when he got to the post, was he eventually uncuffed?
he was.
Okay. And when he got there, he was not arrested immediately for the assault and murder of David Grunwald, right?
You mean arrested as in charged?
Arrested. He was still being detained for purposes of, because your goal was to try to talk to him about this first, right? Before making any of those
That's correct.
decisions. And in terms of the grand jury, I don't know if you have a memory of this, like as far as whether that was a ruse or not. Do you recall that grand jury was indeed set for the next day, or not?
I don't have any clear recollection of that. I mean, to me, that was getting a grand jury subpoena issued. I mean, that's just a procedure.
Yeah.
But it's not really sticking out in my mind.
But you're familiar with that 10-day rule if somebody's in
Oh, yeah.
custody. So Erick Almandinger was in custody as of the 2nd/3rd, so we had 10 days to do that.
Correct.
And of course, we can easily provide the record of the grand jury to the court, and the court likely can get it themselves too, because they keep some of those records. And then, from listening to the tape, it doesn't sound like there was a lot of talking during the transport,
That's correct.
as far as between you and Austin Barrett or Investigator Dave DeCur and Austin Barrett. And was it just, you made a decision to wait until you got back to the post? So
Yeah, that was by design. I'm not trying to spur up any conversation in a car. The whole reason was to bring him back and have a more controlled environment where we could have a nice, gentlemanly sit down, talk with him.
And would you agree with Sergeant Weggson's previous testimony today that in terms of modern practice, it is much more preferable to try to get a person's statement versus arresting the person and not providing them with an opportunity?
Yes,
Or not providing us with an opportunity to gain more information?
Yes.
Right, they can look at it both ways. So was the intent that day to offer defendant Austin Barrett an opportunity to make a statement?
yes,
And I know Mr. Howard looked at some of the, and I'm not gonna go too deeply into the voluntariness if we're gonna continue it, but, I mean, this was not a scripted interview, just to put some of the basics down. This was, you, Sergeant Wiggs, didn't come prepared with any kind of script, right?
I'm not aware of any script that I've ever worked off of. I mean, each situation is its own.
Yeah.
And so no script to answer your question.
Right, but also, since you and Sergeant Wiggs are experienced police officers, you've done prior interviews, is it fair to say that you know at least what could be topics of conversation in an interview with the suspect?
Yes.
Okay, you know, I suppose the interviews can go in a lot of different directions, right, depending on the participants and the answers given, right?
Yes.
Do you consider the interview to be somewhat of a fluid process where you have to listen carefully and be attuned to what's going on and kind of go with the flow?
Yes.
All right. And was your impression, this is again general, I'm not gonna ask too many questions as to the voluntariness, because we'll probably explore some of this later in time, but just generally, did you get the impression that his initial hesitation was because he, as far as what he communicated to you, was because, and this is after he said, yes, I'll answer your questions after Miranda, would you agree that his hesitation, as he communicated to you, was because of his fear of Erick Almandinger, his stated fear of Erick Almandinger?
Yes.
And would you also agree that, you know, if listening to the tape, that eventually the offer was made for him to talk to the DA, and that he kind of jumped on that offer? Would you agree that?
Yes.
That's kind of what happened at the end of the trooper interview?
Yes.
All right, interview at the trooper post, rather. And then you were the one that contacted me, or I know from the tape you were making efforts to get a hold of me?
If the tape shows that that's what it, you know, it's highly possible. I mean, if that's what the tape shows, I'm sure that's what happened.
And it's a short hop from the post to the DA's office. Do you remember if he was handcuffed or whether you guys just?
No, he wouldn't have been handcuffed at that time. Yeah, we just hopped in a vehicle,
Okay.
just came straight over to the DA's office.
And from that, in terms of handcuffing or not, as opposed to when you first made contact with him, having sat in a room with him at the trooper post for a period of time, did you make a determination that he really was not going to be an aggressive fellow during the interview or a dangerous fellow during an interview?
Well, like when we first made contact with him, don't know what his state of mind is at the time. Don't know what he has on him, as you know, as far as weapons.
If he's on drugs.
If he's on drugs, we had some time to figure out kind of what this guy was like, or at least his demeanor, or where he was going to go. And at this particular juncture, towards the end of our initial interview with him and what we were planning on doing, going to the DA's office, we felt like he was calm. We felt like that he had, you know, his mindset was in the frame of, hey, let's go ahead and accomplish something instead of trying to be very, you know, I guess, trying not to cause us any more issues. Yeah, I think he wanted to get some issues on the table, which is he agreed to meet up with the DA.
All right, and you agree that the tape will show that Miranda was read. He said, I'll answer your questions. You recall that?
Yes.
But then later, he kind of did go back and forth, and there was some hesitancy. But at the same time, he continued to answer the questions despite his hesitancy.
Yes.
Like he never walked out and never said, hey, I want this to be done. He never made that type of unequivocal request to cease the interview, correct?
Yes, that's correct.
And then do you recall prior to an offer being made for him to meet with the DA, meet with me, he was the one that raised some concerns about what type of punishment he may be looking at. I think he even said, am I looking at life in prison, right?
When he's asking the DA?
When he, just before, I think, I guess is that it segued from him asking about potential punishment, and you guys said, well, the DA is the better person to talk about those
right,
kind of things,
right.
right? Do you recall that too?
Vaguely, but
Yeah.
yes, that would make sense how we made the jump to speaking between us and then the jump to the DA.
All right, and did you feel that any force was used on him, any physical force or some type of, that you were coercive mentally somehow on him during this interview, either at the trooper post or at the DA's office?
Not how I view things anyways.
In terms of his knowledge, do you feel that he pretty much knew the lay of the land? In other words, were you confident that A, he had likely talked to all his friends about the progress of the investigation and when they were called in and who was arrested, who wasn't arrested, and that he knew that grand jury was coming up, and he knew that David's body had been found? Were you aware that did you have a feeling that when he walked into this interview, he pretty much knew the lay of the land?
Yes.
All right. And in terms of refusing to talk, he even used some terms during the interview at times, like taking the fifth, or when he talked about grand jury testifying or not, he used the term, well, I might take the fifth of grand jury. So he was familiar with some of those concepts also, right?
That's what it appeared to be, or he appeared to have those concepts in his mind.
Right. And did you feel like you or Sergeant Wegson did something just to overbear his will and force him to make a statement that he didn't want to make?
Absolutely not.
And would you also agree in terms of, like I mentioned, the case law talks about full confessions versus statements versus admissions. Do you agree that it wasn't a full confession on his part because he claimed that he was forced to do all this because Erick Almandinger had the guns and he was scared about Erick Almandinger?
Yes.
And in terms of the PC or probable cause, if it was a closer call, I imagine there would have been lengthier discussions between you and Sergeant Weggs and Investigator DeCoeur. And all of you have, what, 15-plus years of experience under your belt at this point?
I think the Corps had about 24 years at that time.
Okay.
Well, probably more than that, but yeah.
Yeah, did anybody feel like it was a close call as to whether there was enough PC to arrest him and detain him?
You know, between all of us, if we had the question, based upon our experience level, and the question of whether we were even in a gray area of doing what we were doing, based upon the heaviness of this investigation, we would have made the call. We would have felt confident to make the call and just run it past someone with more legal.
If there was doubt.
If there was doubt, more legal knowledge than what we had. But that wasn't even a question. It wasn't even a question if we were good to go or not.
Right. I mean,
Doing the tactic that we had planned on doing.
yeah. And it was, is it correct that it was, you had information from multiple sources that Austin Barrett was at the Almandinger house, the camper, the Bronco, and Knick River Road?
Say that question one more time.
Yeah, you had information from a number of different sources that Barrett was a participant in.
Yes.
In these events, right?
Yes.
There was no question that maybe he was not a participant in this when you made contact with him on December 7th?
No.
Okay, thank you.
Go ahead, Mr. Howard, do you have any questions?
Sorry, is it sergeant or investigator? What do you go by now?
It's Mike.
I
Yeah.
can't, I'm not allowed to say that.
Oh, okay, sure. It's Lieutenant then.
Pardon, Lieutenant?
Yeah.
Okay, great. I'm just gonna focus on, I'm not gonna get into the interrogation because I have a feeling we're gonna get to that point down the road. But I'm just focusing on the probable cause matter, okay?
Go ahead.
December 7th. And so you would agree that probable cause is a legal term?
Yes.
Okay. And can you tell me what cases you've read that deal with probable cause? Can you name cases?
Cases that?
Yeah.
Like legal cases?
Yes, like state versus.
No, but I've had classes on it.
Okay, and the classes are taught by investigators or by prosecutors or what?
Well, the class I went to was taught by a prosecutor.
Okay, and who was that prosecutor?
I was at the FBI National Academy Session 276, Michael Petrie.
Okay, did they talk about Alaska probable cause in particular?
We certainly had some discussions, but it was more or less probable cause, how it was established by the federal courts.
And you understand that the probable cause is the same probable cause that an arrest warrant, that you would have to show to an arrest warrant if you went before a judge, is that right?
Mm-hmm.
Is that yes?
Yes.
Yeah, I know you were taking a drink of water there. So, and it can be a pretty, do you find it an easy concept or a hard concept, probable cause? to understand?
I believe I have a good idea of what probable cause is.
So, and what's your, just tell me what your standard, what you think the probable cause standard is for you before you can arrest somebody without a warrant, or detain somebody without a warrant? Why don't you tell me what you think it is?
Well, that's funny because the courts can't even tell you exactly what that is.
That's right, that's right. And so, this investigation is going on, and obviously things are very fluid, things are developing every day, and you're apprised that Mr. Barrett is gonna be down at this food mart. There's a tip, right?
I'm sorry, what's the question?
Well, how did you decide to go down to the food mart? Who told you to go there?
Well, I talked to Sergeant Wagson, who had information about a tip.
So the two of you are going down, and you're in a marked car, unmarked car?
Unmarked.
Okay, and the plan is to see if Austin actually shows up.
Right.
Right. And was there any discussion between anybody, the three of you, we have probable cause to put, we can take him into detention because we have probable cause? Was that concept even discussed between anybody?
Well, let's see, that's 2016. I've had a lot of discussions. I can't sit here and say definitively that there was a discussion or not, whether, gee, do we have enough probable cause on a murder suspect to take him into custody for questioning or not?
Okay. And you don't recall having any conversation with Mr. Kalichak or any other prosecutor to see whether we had the probable cause?
Well, I can tell you, I didn't.
Okay.
I didn't confirm with the DA's
Right.
office, if that's what you're asking.
And you understand that this is kind of a critical, in your training, you must have been trained that if there's no probable cause, that whatever you get of the seizure or the search could be possibly suppressed.
So what's the question again?
That is, if you're wrong on the probable cause, in either in the arrest or a search, because probable cause goes to both search and the.
You mean the court finds that I don't have
Right,
enough probable
right,
cause?
right.
It gets tossed out? Is that what you're saying?
Right.
Well, then yes, that is
Okay.
correct.
So it seems to me that there's two options here. One is, you're waiting to see if he's with other people or not, okay? The first option would be to just have a police contact with him. That is, you're allowed to go up to any police officer, any citizen, and just say, hey, Austin, how you doing? Do you mind if you come in to, we have a warrant, a subpoena we'd like to give you, and a whistle to come in and give us an interview. You could have done that. That's an
Yeah.
option, okay?
Yeah.
And was that dependent upon, when he was in the store, there was only him by himself, right?
He did show up with some other folks.
But did they get out of the vehicle?
No,
All right, so he's by himself.
that's correct. Inside the store.
Right. And so when you saying one of your options was you're fluid, whether he was by himself or with other people, was gonna determine which way you went, the fact that he was by himself, which way were you thinking about going?
What's your question
So the
again?
question is, you were waiting to see whether you're going to arrest him, put cuffs on him, or versus just voluntarily asking him to come, was going to depend upon whether he was by himself or with other people. So,
Were you there, sir?
that's what you just
No,
testified.
no, I'm just asking, were you there, though?
Obviously I wasn't.
Okay, so I'm gonna paint a picture for you. People in a vehicle,
Yeah.
one of his cohorts, windows through the store,
Right,
they see us contacting him.
right.
So you can't really isolate that. They're watching what's going
Okay,
down.
okay.
Okay.
So you could have walked up to him, like any police contact, you know
Sure.
that. You can go up to anybody in the country, you come up to me and I can just walk away, but you can say, hey, Austin, I'd like to talk to you. You could have done that.
Yes, no, it's true. Yes, we could have
Did-
done that.
Who made a decision to put the handcuffs on? Was that your decision?
That was my decision.
Your decision. Okay, so Wegson didn't tell you to put the cuffs on.
No,
Okay. So you could have, second one is a Terry stop. You ever heard that?
yes,
Okay, Terry stop doesn't require probable cause, it's just reasonable suspicion,
yep,
right? You could detain him, you're allowed to frisk him, see if he's got any guns or anything, right? And then you could have asked him, do you want to come in the car voluntarily,
Mhm.
right? And your car has plastic, you could put him in the back, or there's no barrier?
no barrier.
Okay, so you couldn't transport him safely, you're saying?
No, we could, because there was two of us, so yes, we could transport him safely, but if I was by
Without handcuffs? Could you
No,
put him in your
what, no, because I didn't have a cage, I think you're referring to
Yeah,
a cage.
plastic, you know.
Yeah, I didn't have that in my vehicle.
Right.
So based upon the way the vehicle's designed and the nature of who we're possibly dealing with, it was safe to have not just one, but two of us, plus have him handcuffed.
Okay. So are you handcuffing him for public safety, for officer safety, or are you handcuffing him because there's probable cause?
Both.
Okay. You tell him that he's being detained, and then when do you tell him that he's no longer detained? Do you remember saying that?
I don't recall specifically saying you were no longer detained.
I think it was on page 197, but let me show you this.
Are you asking me to go to one?
No, no, no.
Oh.
We'll just let the judge do it on his own. I want to show you page 13. Do you have that? Okay. Can you go to page 13?
Page 13?
Yes, sir. And there you'll see yourself typed there, Sergeant Ingram. And you're talking about, you're talking, there's this discussion by Detective Wigson about the grand jury and how it works, and then you chime in and say, basically, it prevents the cops willy-nilly taking folks off the street, saying just because the cops say that there's enough probable cause to put somebody in the hoosegow, it's a checks and balance system. Right. That's your statement.
Yeah.
So you're familiar with the idea that, police officers shouldn't be taking people off the street without probable cause?
Yes, of
Okay.
course.
And at no time did you, either yourself, all of December 7th, because this goes on from about 1:55, I think, you dropped him off. If you look at the last page, you actually dropped him off, didn't you?
Yes.
Or can you go to the last page? I think it's page 230. It gives a date and time. I think it's 6:03, but 18:03. Does it say that?
Oh, yeah, I say off record at 18:03 hours.
Okay, 33. Okay.
18:03.
03, but that includes all the driving. The whole interview wasn't 4.5 hours.
No, it was
Okay.
driving and.
Right. And he was very pleasant with you. You didn't have him handcuffed. You were talking about country music and all those things. All right. But at no time did you, between 1:55 and 18:03, tell Mr. Kalachek how the takedown went down, or that he was handcuffed and taken forcefully out of that food mart. You never told Mr. Kalachek that, did you?
I don't have a recollection one way or the other.
Okay. And you didn't hear Detective Wegson say that either.
Again, don't have a recollection one way or the other.
Judge, I think those are all the questions I have on probable cause, and I'll pass the witness.
Redirect, Mr.
Just,
Alexander.
in terms of the training, don't you learn about probable cause when you first go to the academy? I mean, it seems like a pretty basic thing that they would talk about arrest and what you have to have, what type of information you have, right?
Yes,
So
sir, that's correct.
In addition to the FBI Academy, did you have some training a long time ago when you were at the AST Academy?
Yes, sir.
And where did you take Austin Barrett back to after the interview?
I don't specifically remember, but it was somewhere near where the fish hook was, but it was at a house, if I recall. I just don't recall exactly what house.
And therefore, in terms of arrest for the murder versus detention, since he was let go to a house of his choice, he therefore was not under arrest for the murder at this time.
That's correct.
Right, thank you.
Okay, you can step down, sir.
Thank you, Your Honor.
Go ahead, Mr. Howard, if you want to go ahead and do your
Yes, Judge.
argument at this point. Go
Yes,
right
Judge.
ahead, sir.
And as I think as, if I may, just throw out something here real quick. No,
Is there anybody speaking?
No, not right
I'm gonna
now.
speak.
Okay, thank you.
I was drawing some, I'm drawing a very crude diagram about the trustworthiness scale. Yes, Judge, as Lieutenant Ingram so cogently noted, probable cause is a very difficult, fluid concept. I mean, all the cases that I've read all say they refuse to adopt a standard, uniform standard, because it's a very fluid concept, and it depends upon case specifics. So what we're talking about here is the warrant clause. And the warrant clause says no search or seizure shall be done without a warrant. And that's what it was drafted as. And of course, we all know, and so the probable cause we're talking about is the same probable cause that would have to be used in either a search or a seizure. So when many of the cases that are looked at often talk in terms of a seizure or a search simultaneously. But there are, of course, we have many exceptions which have been delineated, carved out, which don't require probable cause. What we have, but when it comes to all this, when it comes to seizure of a person, those cases like Dominic versus Mississippi and Illinois versus Brown, they go on and on and on how important the Fourth Amendment is. It's more important actually than the Fifth Amendment. So they're really, they have refused to carve out an exception to warrantless detentions or warrantless arrests. So anybody who gets arrested or gets handcuffed and moved, and you can have, under, for instance, a Terry stop, they can handcuff you under a Terry stop if it's a short duration or if you don't move people. And that can be done with reasonable suspicion. But once you start moving people, and we moved somebody 6 miles, and once you start keeping somebody for that period of time, then you have to have probable cause. And the cases have gone all the way down the line to saying, no, we're not going to allow police officers to do that. So it's the same probable cause. The starting point is the same probable cause that you would have for an arrest warrant, okay? And that's obviously a pretty high standard. So there is a seizure here. I mean, even the state had to concede that there was a seizure, but the defense seems to be that, there was probable cause for supporting the seizure. And so what we have here, Judge, is what is the probable cause? And what I'm saying is that I don't think a judge, from a Supreme Court justice to a magistrate in this town, would grant a warrant in this case for probable cause. And I say that because if it did, I think it would have been found to be improperly granted. So they have to show, what we have here in this case, Judge, analytically, is they have Mr. Barrett with these people, before the homicide. Fine. They have him with these people after the homicide. Fine. But that doesn't mean by birds of a feather flock together. It doesn't mean those associations means a probable cause for his presence during the homicide. So they have hunches. They have reasonable suspicion because of the association before and after. They have, those are great. You can have suspicions. You can have hunches, just like, that's how they do police work, just like, attorneys have a hunch on whether to keep a juror on. Those are okay to do. The problem is you can't arrest somebody or can't detain them. That's not probable cause. So the question here is, from the time period of, whenever that time period is from 11 to 3, what is the specific, they have to show specific and articulable facts that he was there from 11 to 3, right? And that's the evidence. Now, that's the issue. So the hearsay, many of the cases, the state has not cited any Alaska cases. I mean, they cite, an 1814 case, John Marshall. I'm a big fan of John Marshall, but, the Constitution was only 25 years old then. I think there's been, pray tell, I would say there's been some changes in probable cause. He cites a couple of these Supreme Court cases, and we'll go over those briefly, but as I see this case, the state has several options. One is, you know, you're dealing with people from the criminal milieu, see? And this is an Aguilar-Spinelli type of thing, and we're one of the few states, only 6 states follow Aguilar-Spinelli under our Constitution versus Illinois versus Gates. And so you're dealing with the people who are saying that he's there are from the criminal milieu. You know, these aren't cases where they're, you know, the 4-H kids here in town or the captain of the football team. They are criminal milieu. They have been told they're murder suspects. They have every reason to lie. And there is no honor among thieves. So that's the problem in the case, where the probable cause is that missing period from 11 to 3. All they have is Erick Almandinger saying, oh, Johnson did it, no, Austin did it, and I think he may have gone back to Dominic, I can't remember. And they have Renfro saying, oh, he lies about stuff, and then he says, oh, Austin had to be there. So the issue that becomes, and he discusses all these facts, but he doesn't discuss the issue of reasonable trustworthiness. And he doesn't, and that's the issue, that did those interviews provide reasonable trustworthiness so that a reasonable police officer could say to, you know, objectively could say that this person there's probable cause that he was there. So the state could have done several things here. One is they could have just done nothing, you know, because the time wasn't running on Austin Barrett. He wasn't going to go anywhere. Second thing they could have done was they could have done just as I say, see if voluntarily come in, and if you didn't, then they could go to plan B and arrest him. Third is they could go use their so-called probable cause, right, to a police. If they have such strong probable cause, go get an arrest warrant, right? But they don't want to do that because they want to have a shot at trying to get a statement first. Because once it gets the arrest warrant, they're not going to get a statement. So can you imagine the affidavit that they would have to provide to you on probable cause for, you know, the affidavit? Let's go through the affidavit. You know, I've done this, I've done all these things, fine. You know, all the contacts they have previously, all the contacts they have afterwards, but the meat of the matter of when they have to show corroboration is nothing. They would have to disclose to you all the lies. You would have seen all the lies these two guys told. You would have seen how sociopathic Almandinger is. He's a sociopath. He's a psychopath. I mean, if you think you're going to get a psychoval on him, you're nuts. Because I've represented people like him. These kids remind me of the kids, these urchins out of Charles Dickens, you know, Oliver Twist with Arthur Dodger. You know, all these kids running amok. Except they've been digitized into the 21st century. All these kids are, including my client, okay, all they are drugging, drinking, cheating, stealing, whoring punks. They have no concept of morality. I mean, Almandinger, they all live by this code. Well, you know, we cheat. They're survivors. We just try to hang other people. And so the problem is in the case is you want to use, it's like using an informant, right? You have to corroborate what they say. You just can't corroborate, oh, there's a ton of cocaine in the red house that Craig Howard lives in, and I live in a red house. You know, they have to corroborate. It's even worse here, because what's happened here is, and this is the problem, you would have had to disclose all this stuff to you, all of the bad stuff, all the lies. But what happens here, Judge, is they do a number on Almandinger, and it's reasonable trustworthiness, okay? That's the issue, reasonable trustworthiness. This is gospel truth, okay? This is like Jesus is over here at 100%. This is the devil over here. So what they're doing is they are destroying Almandinger, and they're destroying Renfro. Everything he says, you can read all the statements when they're saying, oh, I was gone, I was doing this. They're doing everything they can to get to hear it, to show them that they're untrustworthy, that everything they say is untrustworthy because they want the untrustworthiness, the incredible lack of credibility, everything to destroy these people at their trial. So you have all this stuff going this way. They're not doing anything to bolster their credibility. They don't want to bolster their credibility. They don't want to make them reasonable trustworthiness. They don't want to do any of that. But once they get them to say, oh, Barrett was there, then they're way over here, but now they got to turn around and they want to go on that one point that, oh, Barrett must have been there. They want to make that somehow means reasonable reliability, trustworthiness. And that is the problem with the case. So the problem, if you go to a judge, what will a judge tell you? A judge could say, you know what, I like what you got thinking, but you got to come back. I'm not going to issue a warrant based on this because these people are not credible. They're liars, And Almandinger, everyone knows that at the time of this case, the theory was that Almandinger was the shooter, and he's just picking names out to throw anybody out under the bus. Same with Renfro. Renfro, he's my good friend. I was trying to protect him. Well, no. Maybe the other thing is, hey, I'm going down. Everybody's going down. So they don't do anything. So after destroying them, so that a jury will see they're the most untrustworthy, most non-credible people, and they just lied about everything involving themselves. Oh, this one point, somehow they now realize, once they go this way, with bypass the judicial officer, we got to get over reasonable trustworthiness, and that just throws you into, like I say, the courts are very suspect and have a jaundiced eye looking toward that. If they'd gone with the arrest warrant, two things would have happened. One is the judge, you, would have said, fine, here's your warrant. And then the argument would be realized is, well, they didn't give you all of the information. Secondly, you, as a neutral, detached magistrate, which the Constitution requires, could have said to them, you know what? You got to corroborate this stuff with these guys. These are the only two people who put him there. You've got to corroborate it and come back when you can fix that problem. But the state, inexplicably, it is just totally inexplicably, and I've done a lot of cases, like they just went like a cowboy in here to say, pick him up, and they put the cuffs on him, and they just think they're doing exactly what Officer Ingram says he shouldn't do. Oh, I know all these probable cause. If we allow police officers to determine the probable cause, I always know, I never make a mistake, it's probable cause. But the nuance here is that they don't study the reasonable trustworthiness component, and he does not discuss it in his pleadings. So that's the point of the probable cause that they're missing, because often you're dealing with an informant, but very rarely are you dealing with co-defendants who have every reason to avoid 99 years. So it's a high risk that things aren't going to go well there. So that's why I made such a big deal about Mr. Kalachak, because if Mr. Kalachak had been notified about what they were going to do, then he could have said, well, let's see, because once you go that way, there's no turning back. And there could be serious consequences to the integrity of their case. But these two guys, it's even worse than I thought. I thought Sergeant Wegson, who is, he's basically the chief officer here, would have at least given him some guidance. But what we find out is Mr. Ingram just decides to do this on his own. He has a radio. He can contact Wegson and say, what am I supposed to do here? But they just went in and did it. So, but what I'm saying, Judge, is the state did not want you to look at the trustworthiness issue of them. So, and my problem is, it's not their they do not have the province to decide trustworthiness of people from the criminal milieu, informants. You know, they're informants, but they're now known informants, which is actually worse because, you know, Almandinger is, they know he's actually been targeted as so you have two kids who are targeted as murderers, and that's even worse than an informant. You would think you're going to want to do some, so if there's no probable cause before a judge, then there's no probable cause in the field. And you have to figure out whether you, as a judge, would you have done a warrant on this case? And the issue as a judge is that you would have to look at this reasonable trustworthiness and what facts corroborate that these two guys are, trustworthy. They aren't even in the 50% range. So, of course, the problem is if they decide not to go with a judge, then we end up like where we're here. And it's your job. See, the tough job for you is if they come with you with an arrest warrant, you can at least look at things prospectively. You can say, well, this is what happened, but this is what I think needs to happen. But when you do it this way, what? You have to go back. It forces you to look back retroactively. And it's really unfair to you because you have to look back retroactively and then you have to decide, is that what they did, what they consider probable cause, would that have been probable cause to me? Because it's identical. If you decide that it wouldn't have been probable cause for you, then it's not probable cause for them. And that's the law. So it's and under the state's theory, I say their theory, because you have hearsay in here. Many of these cases they talk about don't involve hearsay, and especially hearsay from people from the criminal milieu. And so there's got to be some corroboration. So you could, like I said, you could have explained to him what I need, but you're not going to get that option. And I say it's a very difficult job for you, especially in the context of a first degree. This is a risk they didn't need to take. They really didn't need to take it, but they did. So you would have heard all about their juvenile stuff, the trap houses, how they live. There's no honesty here for anybody. They don't pay attention to their parents. They hate authority. Parents kick them out or they don't follow. Schools kick them out. They are just doing what they're wilding. And what David Grunwald was doing with these guys that's just unbelievable to me. It's almost like he wanted to have a foot in each world, like he had this great life and everything, but somehow these kids he found attractive. And it's just unbelievable that he put himself in that situation. Because these guys, like I say, Almandinger is a sociopath. I don't know what happened, whether he was born that way, he had detachment disorder, but he's not trustworthy of any kind. But that's the specific problem they put you in. There are no specific facts that can say that he's, the kids will say anything to protect, and so now they want them to be honest, trustworthy kids. Can you imagine? That's what they're saying. Erick Almandinger is a really good, trustworthy person when he made his statements. That's ridiculous. And it's ridiculous for them to have you try to swallow that. But you can't have it either way. You cannot, like I say, you cannot spend all your time and effort destroying people to make them untrustworthy, lousy, just street crud, but then at the same time say, but on these one point, he is trustworthy, reasonable trustworthy. You can't do it. It's one or the other. So, because you see, they didn't know, when they start this thing going, they don't know what Renfro and Almandinger are going to say. And so what they're saying is, these kids are, and then they let them go. See, they let them go, they're reeling, they're hanging in the wind, twisting in the wind. They let them sleep on it. You know what those kids are thinking? I'm looking at jail, I'm going back to my bed, and then they have to come back. They give them like 24 hours to come up with another theories, so then they can destroy him again. But the problem is that they don't know what they're saying, and then all of a sudden they start throwing Barrett's name out, and they say, oh, that's reasonable, that's probable cause. So the issue that I see, Judge, is, yeah, I mean, these kids are like the Artful Dodger kids. Now, except now, they're digitized, they're watching videos, they're watching, violent stuff, they're taking pictures of themselves in coffins, they're doing mescaline, meth, Mucinex, dabs, they just don't care, and they don't care among each other, they don't care what they're telling the cops. So the issue here is, let's see. So, it was like shooting fish for the barrel, but like I say, when you see the state, when you see him on video, it's just, you see how they react, both Renfro, and Renfro's just as sociopathic. When he starts out, he's a tough guy, he's giving it back to the cops, and they just destroy him, and that's what their job is. It's like heat-seeking missile. That's what they want to do, but then they get this one grain, but all of a sudden, and so they're not gonna let a judge see that. No way. No way are they gonna come in and say, these are the two guys that we're dealing with our, so what I'm saying is reasonable suspicion, hunches aren't enough. Yeah, everyone here is out to save themselves. Everyone's highly motivated to, minimize their contact because the more people involved, the less focus there is on them. So let's talk about briefly the cases of probable cause. Brunigar is a case that was cited by them in 1949 case. And Brunigar, or I'm not saying it right, but that was a case where it was a liquor, this is a 338 US 160 1949. And it was a case involving transporting intoxicating liquor. And what happened in that case is that there was a seizure. The federal agent who seized the petitioner had arrested him previously, 5 months earlier, for illegally transporting liquor. And he had twice seen the petitioner loading liquor into the car in Missouri, where the sale was legal, and he knew he had a reputation for hauling liquor. So then they stopped this guy. They recognized the petitioner as the same guy who appeared to be heavily loaded going west into Oklahoma from Missouri, and then they stopped him. And they basically say that the officer's knowledge that the petitioner was engaging in illicit liquor running was not based wholly or largely on surmise or hearsay. The facts are derived from his personal observation were sufficient in themselves without the hearsay. And so based on that, they say, look, the guy's seen him before, he knows who he is, and there was no hearsay to be corroborated. And in that standard, what the probable cause standard that is set is probable cause exists where the facts and circumstances within the officer's knowledge and of which they have reasonable, trustworthy information are sufficient in themselves to warrant a man of a reasonable caution that a crime is being committed or has been committed. So this is where we get the reasonable trustworthiness, right? And that has to apply, the reasonable trustworthiness has to apply, you have to apply it to Almandinger and Renfro. And that is going to be a hard pill for you to swallow, in my mind. Maryland versus Pringle, he cites. This is 2003 case. In Maryland Pringle, this was a search of a car where there was a bunch of cocaine. And one guy says, hey, I was just in the car. And what he says, they say that they have probable cause because the substance of all the definitions of probable cause is a reasonable ground for belief, citing Brunigar, and the belief has to be particularized with the person to be searched or seizure. That's Ibarra versus Illinois, 444 US 85, which means that in Ibarra, what happened is they went in thinking one guy had cocaine, but they decided to search everybody. They had they had probable cause for one person, but they said that doesn't mean you can look at everyone else. The probable cause, they have probable cause. Almandinger, and they give them the probable cause. That's how you got the probable cause for the warrant, from their confession, right? So they did it right there. They got the confession. They can incriminate themselves. Then you can say, oh, I got the probable cause. So, but you can't use probable cause that these two guys did and then say, well, we're going to use it for this other person. It has to be particularized toward that person. And they cite Ornelas, which is cited by him. So now, Schmid, which is an Alaska case, I did yesterday. I tried the best I could because I'm not real good on the computer. But Schmid, which is 615-565, it's a search case, because most of these are search cases. That says that, they cite Erickson. This is an old case, but, basically, citing page 574, the officer's good faith belief is not sufficient. What's required is there be facts and circumstances known to the officer which would justify a prudent person believing an offense had been committed. Again, probable cause may be based on reasonable, trustworthy information from an informant or some other person. But that's again, they have to show, and that's where their analysis just caves in, because they can't establish the reasonable, trustworthy information, because there's no other witnesses to corroborate what they said. See, they can't say, oh, Austin was the one with the gun, because there's no other people who saw that. So that's in Schmid. He wants to cite reasonable trustworthiness, but he doesn't cite an Alaska case. There's an Alaska case for you. There's another Alaska case called Cruz. And Cruz was an outrageous thing where they just go through it's a 1978 case, Alaska Supreme Court, because we didn't have it in the Court of Appeals. And that's 584-1141. And they cite on page, I think it's, someone must be around page 1144 or something. But they actually cite Brinegar in whole, citing that the test for probable cause is stated in Brinegar. Probable cause exists with the facts and circumstances within the knowledge and of which they have reasonable, trustworthy information are sufficient in themselves to warrant a man of reasonable caution in the belief that a crime has been committed. So not only do they have to have their own knowledge, but they have to be armed with trustworthy information. And they don't. What we have is, these incredibly lying people saying someone has done that. And that's why, Judge, that's why they didn't do an arrest warrant with you. Because there's two things here. They got this new thing now where they try to get the statement first, somehow get a statement, either illegally detain people or get them in there, and then try to use that in trial. And that's I can see the theory, but you can't be crossing the Fourth Amendment and I tried the best I can to find a case that is as close to this case as possible. And that's why I'm telling you, as my officer of the court, I think I probably have to divulge this case, even though he couldn't find it. And I think you should look at this case, because it could be gone either way. It's called Shorty versus State, okay? And this is a 2009 case. It's 214 P3 374. And this is a case that, for some reason, that doesn't talk about the reasonable, they resolved it by not going into the reasonable trustworthiness information. Perhaps they didn't have to decide it. But here's the fact pattern. This young lady, is walking downtown by the transit center, and four men come up to her, and one of the men trips her and took her backpack. Then a younger man held her down while an older man raped her and punched her repeatedly. Okay? And then the younger man raped her after the old man finished, okay? That's the fact pattern, you don't have to read the fact. Then it says, somehow the third man that then alerted his companions that the police were coming, and the 3 men fled. But I guess the third man wasn't involved in the rape, he just kind of watched it. That's when you read it, okay? So the question is, what happens in this case is they decide there's probable cause for sexual assault, in this case to arrest him without a warrant. And they talk about the reason, and Judge Bolger uses a different standard than the reasonable trustworthiness, and I don't know why he does that, but I don't think he needed to, but what happens is the detective shows up, and he gets a statement from the victim, and he gets a statement from this guy named Thomas Leipke. And it's unclear who he is. It's unclear whether he's one of the 4 people, or whether he was one of the 3 people left, or whether he was one of the 2 who short being the guy, the other rapist. And Leipke tells the police that he confirmed that she had been raped by his companion named Shorty, who he had met in jail. So it's unclear who this Leipke is, whether he's a criminal suspect or whether he's just a friend who happened to be there. His statement identifying Shorty was corroborated by the police by the details of the victim's statement. They then got his photograph of Shorty from the jail, and they were able to show that he had been in jail with Shorty. And then the correctional facility said had been together, and then she picks out the photograph of Shorty, okay? And they're saying based on that was enough probable cause to arrest. And it has some similarities to this case, but it has real differences, because what's missing here is you don't know who Leipke is. They don't tell you what his position was, whether he was a citizen informant or whether he was the guy who took off with the backpack, or whether he was one of the 2 rapists. See, if he was one of the 2 rapists, then it would be more akin to this case, right? But if he's not one of the 2 rapists, then it's in the analysis is completely as a citizen informant, which you don't need as much corroboration, right? So I urge the court to look at that case, but it's about this. You would think that with the number of homicides we have in this case of violent crime, that there'd be more cases, but I did the best I could to shepherd. This electronic shepherdizing, this is the only case I felt, and I felt the court needs to look at this because it may be helpful. But the bottom line is the reasonable trustworthiness test of Brenniger is still the law in this state. The Supreme Court has said it. Lindsay, is the one case that cites Dunaway, and I'm not gonna go over that, but my analysis is, again, they got a lot of evidence to show these guys were together before and after. That's hunches, that's suspicion, that's good police work, but they can't use that. They can use that as a springboard to try to establish probable cause, but they didn't do it in this case. The problem is, the probable cause has to be found sometime between, I don't know. There has to be probable cause to show that AB was there sometime between 11 and 3, whenever that the event happened, when he decides he doesn't want anything to do with this anymore and leaves. And that information has to pass this standard that is very high. And you read what he says in his opinion, he never talks about reasonable trustworthiness. He completely omits it. He just skips the fact, we have all this other, he said that, he said, sure they said that. The question is, the $64,000 question is that reasonable trustworthiness test? And I say it isn't. And I think, frankly, this may be a case, as far as I can see, at least in this jurisdiction, maybe in other states, but I think it's a case of first impression, just the way the fact pattern happened, that what is, when you have 2 people, one person's already been convicted of murder, everyone thinks he's the murderer, what standard are you supposed to apply in determining, whether that's reasonably true? Notice they use the word, the Supreme Court, and we have adopted it, this is where it gets even more complicated. And for detective, for Mr. Ingram to say, oh, I understand probable cause, he doesn't understand this, I guarantee you that. What is reasonable? That's the bottom line question. It doesn't have to be, because we're not dealing with beyond a reasonable doubt, we're not dealing with the standards. What is reasonable trustworthiness? And I'll leave it to you to figure that one out. But that's what you would have had to do. What you have to do for me to lose this case, you have to put on this motion, you have to put yourself in a position of, okay, these guys show up and they tell me this stuff, but then they say, Erick Almandinger says, back and forth on the shooter, and then, which shows he's not trustworthy in the first place, and he's lying about himself. And same with Renfro. And you have to say that those two statements are trustworthy, reasonably trustworthy. And then that's the only way to PC. Because what you have to do, you have to fix up the mess that they made. They made a big mess here. Ingram just decided on his own, this is what I'm going to do. I know probable cause. I've been to some academy. And he doesn't know probable cause because in this instance, when you're dealing with criminal milieu, informants, defendants, it's the reasonable trustworthiness. That was the law of 1949. It's not new. If they had called Roman Kalachak, and he's very, very good, he's very competent, he just wants things done right. I guarantee you, Roman Kalachak would have, if he had problems about probable cause or didn't know his probable cause, you can get to reasonable trustworthiness. Just push the button, probable cause, what's the standard for people of the criminal milieu. So I don't know what his Ingram's experience with people of the criminal milieu. He doesn't know Aguilar Spinelli. I could have thrown Aguilar Spinelli out and he wouldn't know what the heck that was. So that's the argument. And it's kind of I think it's a pretty good argument because I don't know what they're going to say because they would not touch, they just throw the word out there, but then that concept doesn't help us unless you apply it to the facts. So you're going to have to say that statement comes in. And of course, Judge, this is kind of a crucial thing because if I win this, we don't even have to meet with the Miranda stuff. They can go back to the grand jury without a statement. So this is my plan A. And it's a pretty good motion, but I'm telling you, my Miranda motion is even more compelling. But I like to hear what Mr. Kalachak says here because you're going to take people who are totally untrustworthy. They're liars. That's how they live their lives. That's how they survive. But this one little grain, it's reasonably trustworthy to me. And I don't think that's where I get to the fact that I have friends who are all judges all over from the Supreme Court down, and I don't think any one of them would have said this is, because it's a weird concept. And frankly, until Mr. Kalachak pointed it out, I had no idea about this reasonable trustworthiness component when you're dealing with probable cause and dealing with people of the criminal milieu. And so I thank him for that because it's always interesting to get a new. I always like to grow professionally. If you have any questions, Judge, I'll be free. Like to answer them if you need. Otherwise, I'm going to start repeating myself.
Okay, go ahead, Mr. Kalachak.
Well, Judge, we have, the way prosecutors look at this is we see probable cause as a pretty low standard. Of course, we deal with what the defense attorneys call the highest standard in the land, and that is beyond a reasonable doubt in trials. But probable cause, we consider that a very low standard. Anybody that's gone to district court arraignments on a daily basis, as all of us do, every day at 1 o'clock, I've gone there for years. I can probably count on one hand how many times judges have not found PC, as we call it. And usually it was because a police officer forgot to put the value of the thing stolen or the thing destroyed, and we couldn't fill in that gap. And I don't think the legal definitions really show it to be anything different. I mean, we provided it in our brief. I don't want to go back through our brief, but it just says the U.S. Supreme Court has held that the substance of all the definitions of probable cause is a reasonable ground for belief of guilt. And it definitely is, quote, less evidence than would justify a condemnation or conviction. And then obviously, the higher courts have told the courts what should be examined. It's exactly what we did today, is all the information known to the police before the detention. And the test is the court must evaluate if the facts and circumstances within the officer's knowledge and of which they had reasonably trustworthy information were sufficient in themselves to warrant a man of reasonable caution in the belief that an offense has been or is being committed. Now, and I know we elaborated more on our brief, and we did spend, I would say in our brief, more time on the facts known to the police. That was the bulk of our brief, because I think that is those are the crucial things the court needs to look at. I find Mr. Howard's argument today very interesting. And I think it's more interesting because I compare it to some previous arguments in these cases about the defendants. And as to the issue of reasonable trustworthiness, it doesn't have to be 100%. It just says reasonable trustworthiness. But if we're talking about people in the criminal milieu, his client was the one that was most in the criminal milieu. And that's not the information they were counting on when they arrested him, but he's the one that was involved in that kidnapping/robbery case. He was the one that was in the room when Frankie Woodford was shot and killed. He was the one that had Dominic Johnson's grandfather's stolen watch on his hand in the photograph. So criminal milieu, that's Austin Barrett and Devin Peterson, I would say, too. But despite, Mr. Howard, who is representing Austin Barrett, obviously, calling Almandinger a psychopath, despite him calling Renfro a psychopath also, from what I heard. And we know Alana Peterson is, connected to Devin Peterson, but I think when the court looks at reasonable trustworthiness, of course, the officers had a hard time with all these people. Everybody's throwing up roadblocks. Everybody does not want to be involved in this. Everybody is lying to an extent. But I think what the court needs to do is there are some definite common denominators. In other words, if we put strings in all their interviews, there would be certain places where all the strings intersect 100% without any doubt in the world. And that's where we get the reasonable trustworthiness. Almandinger puts Austin Barrett there, not only in the camper, not only in the Bronco, but at the murder scene. And at some point in his interview, he puts him as the shooter. I know that's a problem because they're all doing the finger pointing. And I think, but the court's seen murder cases before, Mr. Howard has, that is what people do in these kind of situations. They'll give, in these interviews, they'll give the police officers bits and pieces, but at the same time, they're going to try to protect themselves. And that's exactly what was happening here. Almandinger says that he was there, but he blames Johnson and or Barrett as the murderer. And then Renfro, it's the same thing. At first he lied his butt off, then he said maybe the most he did was burn the Bronco. Eventually he gets to the same place the other people get. The common denominator, who was there? Dominic Johnson, Erick Almandinger, Austin Barrett, and Bradley Renfro. There was no deviation. I can see if there was some deviation, but all the people, and the information that the police officers had before contacting Austin Barrett primarily came from Erick Almandinger, Bradley Renfro, and Alana Peterson. But in terms of trustworthiness, Almandinger was called a child by his attorney in our previous hearings in the trial. They're going to be trying to get the lowest sentence possible because these are kids. These are children. They're not career criminals. We've heard this before. Bradley Renfro's attorney, Chris Provost, specializes in juvenile justice, and we know where he's headed with the juvenile brain and the development of the brain, et cetera, everything to mitigate the possible penalty in this case. Now, but when it suits them, they're all part of the criminal milieu. Not really. Austin Barrett and Devin Peterson, yes. We have established that they were involved in other criminal cases. Almandinger and Renfro, I don't think the police officers, I questioned them on the stand, they didn't really have any knowledge about Almandinger. He was not on their radar. Renfro was not on their radar. Neither were Austin Barrett and Devin Peterson, but we know that they were on the radar of other police officers investigating other things. But there is no doubt that, yes, did Almandinger say some lies? Of course he did, especially in the early phases. Did Renfro? Of course he did. He denied being in the Bronco. He denied burning the Bronco initially. Almandinger said he was at a party in Anchorage initially. So yeah, they all lied. But eventually, when we get to those bigger interviews that are in the binders, there is a lot of common ground. And the common ground is that all four of these people were in the camper, in the Bronco during the transport of David Grunwald, and at the murder scene. No matter how you slice and dice them, call them what you want, whether they're kids or psychopaths, they all give the same story at the end, roughly. All they do is minimize their participation. And if we take it one step further, let's put Austin Barrett, even though the analysis doesn't really relate to him as far as what the officers had beforehand, he does the exact same thing. He lies, and he's immediately slapped down saying, no, that's just a lie. He said he wasn't in the Bronco, for example, early in the interview. But later, at the end, he admits being there, and he names the same participants, so the court shouldn't be concerned about reasonable trustworthiness. All of them acknowledge the same four people were there and involved in this group. All they're doing is they're minimizing their own involvement, and they're pointing the bigger fingers at the other people. Where Alana comes in is that, and the court knows she has issues, but honestly, from previous trials, out of all the witnesses, I had to do the least amount of impeachment and confrontation with her. And she testified exactly previously as Sergeant Ingram described in her interview, that she described that Austin Barrett was dropped off by the same group that was named by Almandinger and Renfro, and this is where the corroboration comes in. And they had the Bronco. We know it wasn't anybody else's Bronco, but David Grunwald's. And then the court is obviously familiar with the other corroboration as far as the taxi, what the court has seen in the previous trials, the phone information, the taxi information, etc. But Alana provides important corroboration that he was dropped off. She didn't want him to spend the night at the house because he was acting so suspicious and so paranoid. And he ends up sleeping in the winter, sleeping in a vehicle without the heat on because he is so afraid that he's going to be found by the police or whoever. And then, of course, I know it's a small thing, but it is pretty important that some of the defense possessions were found right with the guns. Now, I know it's true that Austin Barrett called Devin Peterson his brother, and during some of the interviews the court will see, he said that Devin Peterson let him stay at the house, etc. But it is important in terms of when we're talking about was it reasonably trustworthy for the police to believe that Dominic Johnson, Erick Almandinger, and Bradley Renfro and Austin Barrett did this. We have to look at all the things that support that notion. But in terms of the scale there is nothing, they don't say anything else. They don't say anything about one person, except for those initial lies where they all denied being involved. At the final stage during the big interviews, they don't vary from who was the participants in this particular case. The other thing is, in terms of probable cause, the court obviously understands that our indictment, the arrests and the indictments were predicated on the accomplice liability statute. And our argument is that not only is the probable cause an extremely low standard, it's probably reasonable suspicion, probable cause, probably the lowest standards in the criminal justice world, but then the aider and abettor statute is pretty favorable to prosecutors. It's a pretty potent tool for prosecutors because it encompasses activities such as encouragement, the promotement of an event, enticing somebody else to do it. And the statute and the case law even says that the person doesn't even have to be there if there is enticement or promoting of the offense or helping in the planning. So that is also favorable too, as far as if a judge got a complaint against Austin Barrett with the same information as we would provided today, my bet would be that the judge, the magistrate, whoever is doing arraignments and whoever looked at that would find PC on this, because they would also take into account the aider and abettor law, which means we don't have to prove who shot the gun, we don't have to prove who pulled the trigger. We just have to prove that they were there and they knowingly helped. Now, trustworthiness, I mean, it goes without saying that 2 juries have already found our evidence to be extremely trustworthy, because we already obtained 2 convictions against 2 of the defendants here. And in terms of the conduct of the officers, as to the motion that's on the table right now, did they have probable cause? Well, we're not dealing with, first or second year police officers. We've been dealing with officers that have done it for a long time. And they may not be able to recite the case law, all the magic words that the Supreme Court of the U.S. or the Alaska appellate courts have used in describing PC. But I submit to the court, they do so many arrests. They can arrest anybody on a felony based on probable cause. So many arrests that eventually it's one of these things, just like lawyers have this instinct of when something fits a certain category or not. Police officers develop the same instincts, especially when they reach that 15-year, 18-year mark. And all these officers are clearly experienced officers. So not only did they have that training that's probably in the back of their mind at the academy, and some refresher trainings either through evidentiary hearings in court or through other trainings they've gone to, like Lieutenant Ingram described, but also they've done these cases a number of times, and a lot of it, just like for lawyers, is learning by doing, and I believe they develop an extremely good sense and intuition for when probable cause exists or not, because nobody wants to arrest people if there's no probable cause. I don't think there was any evidence that there was anything underhanded about this. Was the investigation perhaps more proactive or aggressive than some of the other ones? Of course it was. There was a missing child. And I would say before December 2nd, it was pretty much all hands on deck as far as trying to figure out where David is, or figure out if he was killed. But the court knows that this interview happened on December 7th, which was a number of days after David Grunwald's body was found. There wasn't, I would say there wasn't, from the evidence the court can see, there wasn't that sense of urgency as far as that everything had to be done that was humanly possible to figure out the situation, because he still could have been alive. But it is true that grand jury was scheduled for the following day. So there was a timeline here which necessitated certain events to take place. And in this particular case, I think just their testimony, this was not one of those calls where it was a hard one. Is there PC or not to make this arrest? There were a number of people that put him at the scene. Erick Almandinger even put him as the shooter. A witness who is not involved in the murder. Alana Peterson, though she's had her issues, she was not involved in this murder, and she puts him with the group right after the murder, before they go burn the Bronco, stepping out of the Bronco and coming into.
Which is the vehicle theft charge, right?
What's that?
And that would be to the vehicle theft charge, which he was indicted on?
Right. And it was right immediately, they went straight from the murder to Alana Peterson's house. So that's additional, and this goes again to, when Erick Almandinger says Barrett was there, is that trustworthy? Well, compare it. Alana Peterson says he was dropped off by the same group using David Grunwald's Bronco shortly after the murder. So when Renfro says that Barrett was there, and Renfro and Barrett are buddies, I'm sure they synced up before they made their statements, but when when he says Barrett was there, is it reasonably trustworthy? Is that particular statement? I don't think yeah, sure he lied. We acknowledge that he lied, and that's what made this difficult. But when he made that statement, and we should focus just on the statements relating to Austin Barrett. When he said, my buddy Austin Barrett was there in the camper and in the Bronco and in the woods, is that reasonably trustworthy? Yes, because again, a lot of Peterson puts them dropping off Austin Barrett right after using David Grunwald's Bronco right after the murder. So again, I mean, I think it's like they all intersect, there's common ground, and the common ground is they all say where things happened. And they all verify that there wasn't a bad assault. They all verify that David Grunwald was taken in his own vehicle to his own death. And they all verify where it happened, and they all verify that they were the participants. So say what you will about, whether they're psychopaths or not, whether they're criminals or not, whether they're liars or not, even liars and even psychopaths in this case have agreed to the basic facts. They agreed that David Grunwald was beaten, kidnapped, and killed, and they agreed that they were all there when all those things happened. And that, in the prosecutor's mind and the police officer's mind, is probable cause for arrest.
Well, gentlemen, the court's going to address a couple of issues real quick. Regarding the probable cause, I will take that under advisement and review the case law and the information that was presented today. Mr. Howard, regarding your motion for a continuance,
Yes.
I am going to go ahead and grant that, given everything that was given me today.
Thank you,
And I am also going to grant your motion to sever.
thank you.
And regarding the motion to sever, it is the court's opinion, having reviewed both the information provided today with the interview with Mr. Barrett and some of the information provided with the interview with Mr. Renfro, that this should have been done probably quite a while ago. I think there are brutal issues that could have easily arisen at trial, which really would have made problems for the court and could have ended up in a mistrial. And I'll just give the parties one example I was looking at. Let me see if I can find that. Essentially, it's a statement that was made in the interview with Mr. Barrett. And he makes a statement concerning Mr. Renfro, that he asked Mr. Renfro as they were getting into the car to take Mr. Grunwald out to the woods, that you know where we're going with this. And Mr. Renfro goes, yes, I know where we're headed and what we're going to do. To me, that could easily be showed as evidence of intent by Mr. Renfro, that he knew what was happening, that he was adopting the mental state of either Mr. Almandinger or Mr. Johnson, whichever one you like him to be the shooter. But the interviews provide problems for the courts. And I think that it could have easily come out at trial. Something could have slipped, got set through, that would have really created a brutal issue. So I think in order to protect both these defendants, I think the motion to sever is very warranted, Mr. Howard.
Thank you.
So I am going to sever both of these, given the length of the interviews that was done with both these defendants. We will go ahead and do the trial with Mr. Renfro next week, as scheduled. We already have the questionnaires. It shouldn't be very difficult to just advise the jury that we're only going forward on one. So I guess, Mr. Kalachek, at this point in time, I've granted the motion to continue, the motion to sever under advisement, the motion for PC. Is there anything else you want me to address before next week?
I guess I'd have to look back at our motions and see
I mean, there's three issues.
who the authors were of the motions.
Well, Mr. Provost has three motions left that I am addressing. One is the aggravator, which I think I issued an order just a few days ago.
Okay.
The other one is the Snapchat video, which I will get out before next week. And the third third one was, let's see.
I think there was the issue of like how much of the gang evidence comes in, and again, I'd have to look and see if that was joined, if Mr. Provost.
No, I don't think it was. Let me see something real quick. Mr. Provost, are you there?
Yes, I am, Your Honor.
Okay, I know you're not on record in this case, your client's not there, but I just will give you an opportunity. Do you want me to set this on to address anything else before the Monday when we start looking at the jury questionnaires? Or do you just want to see what we have at that point, so?
Well, I've already got a ticket to leave first thing in the morning so I can get to the courthouse and grab
Okay.
that box of questionnaires. But I do have a question, well, to address the last issue, as far as the gang activity, I did intend to just file a quick joiner, and I intended to be out there this morning as well.
Yeah,
And
well,
present it.
if you want
And
to,
I figure as well, you know, I can make that oral motion and still preserve the record when the time comes.
I think that's correct, and the court can rule at that as we go forward.
court has
I gotta
no-
see what information it goes to Mr. Renfro, to Mr. Barrett, to get, not all the pictures apply to all of them, not all the commentary, not all the Snapchat, not all the Facebook applies to each defendant.
Right.
I will
And
look
Your Honor, I'm quite mindful of a comment you made at one of the trials. It was not in front of the jury, of course.
Mm-hmm.
Something to the effect when, I think it was Mr. Kohler was, pretty much has literally a standing objection on,
Right.
gang stuff. But, and the court made the comment, you know, almost out of, well, with a certain amount of expression to it, you know, that has to be looked at on an individual basis.
I think we can deal with that in Fairbanks, Mr. Kalachek.
Well, and I'll still remind the court and counsel that one of the options we have is showing that one of the defendants is the murderer, the others are the accomplices. So, for example, Almandinger's gang stuff, you know, that could be relevant, even if he's not on trial. And then again, you know, if Barrett and Renfro are painting Almandinger as the bad guy, I don't see why they wouldn't want all that in, because that would help him paint him as the worst one, as the psychopath of the group. But the court has our pleadings on the gang stuff anyway,
So I'm just gonna note for the record that you'll have to make it when we go on record in your case, sir, but I will note them at the back of my mind that you basically gonna be making this motion in limine when we get to Fairbanks, okay?
Yeah, thank you. As far as there is the voice recognition issue.
Oh, yeah,
I sent-
that's part of the
I sent
Snapchat
the-
one, right?
Pardon me?
That's part of the Snapchat issue,
Right.
yes.
And I sent, again, I was going to drop that off as well today. I sent Roman the final report that I got last Thursday or Friday.
Okay, okay.
It's just age longer than what I've already filed in the notes. But the question I have regarding that is, and the state does not oppose telephonic testimony. I need to lay a foundation for that report, and quite frankly, depending upon the court's ruling, you know, unless we can get his testimony, I told Roman it would be pretty brief on my part, you know. I don't think his testimony would take more than an hour, not even that much on direct. But it's either that or I you know, will hear the testimony of witnesses and I call them in the defense case as a rebuttal witness. So it would be great if we could get that resolved. If the court is going to rule on it, I do want to make sure that this expert report is part of the record, and preferably his testimony about whether it is, he's not going to be reaching specific conclusions because he's only listened to the snap video and the sampler, which was here's one of Renfro's 2-hour interviews, so there was plenty there to work with. But it it's a very, I mean, it's a very important issue to Renfro that, you know, this reference, this, you know, whether it's as a lay person or as somebody that has interviewed Renfro himself, the statement, a statement or reference, oh, yeah, it started out at Dominic Johnson's trial is absolutely Renfro. And the witness that took the video said she couldn't recognize whose voice it was. The expert report and the analysis with three individuals, three males talking over each other over a period of about 1.2 seconds, it's so highly prejudicial that even if there was, it would outweigh any other factors or considerations. It's simply unreliable and clearly highly relevant to Dominic Johnson's trial, but it's just not enough of a voice for whether it's a computer, a trained ear, or a trooper, or any of us lay people. You know, I've had hours and hours and hours of conversations with Renfro. I can't tell whose voice that is. Not that it matters, but I think
what we're going to do is when we get to Fairbanks, I'm gonna have a motion to limit a hearing on that issue and listen to it again on record in the Fairbanks courthouse, and then we can kind of go from there. Okay?
I'm not sure.
Okay.
I'm not sure what the concern is by Mr. Provost, really. I've listened to what he said, but is this concern that whether he gets to call his expert?
I think it's just his argument in support of his motion to preclude. So I think at this point in time, I'm not gonna discuss it anymore. His client's not here.
Okay.
But we'll deal with it next week. And the three motions I have listed at this point in time is the motion to preclude the state from introducing evidence of uncharged bad acts and to redact any reference to such acts in defendants' interviews. There's no opposition to that. So I take it you're prepared, in that one, Mr. Kalachek, to redact all the information regarding the uncharged acts, right?
Either I could do it or Mr. Provost. You know,
Okay, so
I wouldn't-
that's not opposed. So you guys just have to get together and make sure whatever in the interview that you're
Right.
playing doesn't have any mention.
We're talking about the Wasilla robbery that he was never really
Right.
charged with anyway, but I still, the gang stuff,
Well, this isn't about the gang
Right,
stuff.
right.
This is about that was about that. And then there's the Snapchat, and then there's the motion to dismiss aggravator, which I already ruled on.
Now, the video, I think the evidence is pretty clear that Renfro was there when it happened. It actually,
Well, I'm gonna watch that again and just
actually,
so we have a,
if Mr. Provost and the court wanna watch the video, it's actually the same jacket. He's got another photos. You can see his hand right by Dominic Johnson with the same jacket sleeve. I think the evidence, and I think they even acknowledged that they were there. Austin Barrett and Bradley Renfro acknowledged that they were in the shed. So I don't, you know, I think it's like the voice thing I understand, and I'm willing not to really fight the Dalbert issue, because the standard for experts is pretty low. And I think it's more of a, if Sergeant Wigson is still of the opinion that in his opinion, it was Bradley Renfro's voice. Process of elimination, Dominic Johnson is doing the major talking. It's either Barrett or Renfro doing the side talking.
we'll just have a hearing on that motion to eliminate when we get there, okay? So at this point in time, sir, I will see you all at 10 o'clock on Monday morning in Fairbanks then.
Yeah, and I think I raised this before when we were dealing with jury questionnaires, but now that we're severed, it's even more, well, it makes it a lot less complicated. But I am producing a few of the jury instructions involving mens rea jury instructions. I am going to be proposing some of those instructions. They're going to be tailored to what is commonly nowadays referred to as the juvenile state of mind.
Okay. All I ask, Mr. Provost, is you get those to us as soon as possible, so
Right.
that both myself and Mr. Kalachek can look at the law regarding that issue, okay?
Yes, yes, sir.
All right. Okay, any questions, Mr. Howard?
No, Your Honor, my client's in Fairbanks, I don't know if Your Honor has the authority to order him down.
Well, I'm gonna have to, as soon as I get to Fairbanks, I'm gonna have to talk to them up there about a real trial dates, cause again, it's
Sure,
contingent on their availability.
Right, but I don't know if you can, I mean, I'm gonna start working on my motion to suppress, I don't really know.
I will get him back down here and
Okay.
probably set a hearing in maybe 60 days, 90 days, something like that on this case.
Sure.
But I also need to figure out a
Logistics.
realistic
Yeah,
trial
logistics up
date.
there, thank you.
All right?
Yeah, and just so the court knows, it's a little bit of a game changer that we're dealing with one defendant. I think some of our witness planning presumed that jury selection would be a little longer with two defense attorneys.
That's okay, Mr. Kalachek. We have a lot of flexibility once we
there's gonna
start.
be-
Yeah, I missed the comment, something about no longer have two attorneys.
Well, I always figured that jury selection might be longer because two attorneys, there's one more person talking during jury selection, but.
Right, and
we
at
might-
trial as well, but, I think, with this jury pool in Fairbanks, I'm not too concerned about getting a jury pool that, is not, tainted, so it should go quicker getting a jury with one attorney and, even with cross-examination of state witnesses with one
Well,
attorney.
I've already put out to the jury that the evidence won't start till Tuesday after Labor Day. That gives us next week to pick the panel.
Right.
So that's pretty much been told to everybody that's coming, the 150 jurors, so,
All right.
all right?
We
so
kind of
we'll-
told our witnesses we're looking more at September 9th, thinking that it might take 2 weeks, but,
Oh, okay,
but we,
we'll
you know-
start with what you got. You got your
Yeah.
officers and you do what you can, okay?
all right.
And if we don't have to do anything on that following Friday, if you need a 3-day weekend to get the rest of them up there, that's Fridays. I told the jury that it's gonna be flexible, so.
It just means more gray hair for the paralegal, but we'll figure it out.
Okay, so we are off record. Mr. Howard, I'll be setting a court date for your client as soon as I can.
Thank you, Your Honor.
And get out of TO to have him brought back to Palmer.
Thank you.
All righty, we are done for the day. Off record.